thing before we kind of jump back in things and get going, I do want to take just a few minutes and look at some test questions from Unit 1. So if you guys will go ahead and grab your books, and let's all turn to page 17. And you know, Unit 1 it's very basic, including the questions. So please don't look at Unit 1 and think, oh, this is going to be easy, I got this. I promise you, as we start going, things are going to get more in depth. And the questions are going to get more difficult. So this is why I like to start simple, so we can build some good habits, form some good habits, and help prepare us for the more in-depth questions, the more heavily tested questions. So just a couple tricks, if you will, that I'd like to offer you guys. Remember the other day we talked about your absolute words, paying attention to those. So those were words like must, always, never, all. There's no wiggle room to those kinds of words, and we'll continue to point those out as we go on in class. One approach to some of these test questions, again, as they start getting a little trickier and a little trickier, one approach to these test questions is to read the question. Well, first off, we're always going to read the question, and we're always going to read all the answers. Okay, guys, I'm here to tell you, one word can change the meaning of the whole question. One word can change the meaning of the whole answer. So the first thing I need you guys to do is just read the question. And questions typically have what's known as a stem. The stem of the problem is the actual question. Guys, the question is our focus. It's usually the first sentence or the last sentence, and that is your focus for this question. Sometimes we like to run down, I call it the what if trail. Well, what if this? What if that? And as soon as you start asking yourself what if or what about, you've derailed from the stem. You've gone off track from the stem of the question. So the first thing we're going to do is stay focused. Now, some of you in the past have told me that, you know, it's hard for you to focus on that question. So one thing you may want to consider for both of your exams, you have scratch paper. So one thing you may want to consider is, you know, jotting down the question, or at least that key term or something, and circling it real big so you can see that on your scratch paper. And again, it's all about keeping that focus on that stem. So we're reading the questions, and then when they start getting trickier, if you find yourself in a test question that you're not sure of, one approach that you may want to take is to treat each answer independently and give each answer a true and a false. So in other words, you read the question and then you say, is A true or false? Is B true or false? Is C true or false? Is D true or false? And by the time you go through that little exercise, you're going to have either 3 trues and 1 false, or 3 falses and 1 true. Does this make sense? So then you can kind of, what we're looking for here is the odd man out, the 1 true or the 1 false. So for example, on page 17, let's just look at number 7. Number 7, again, is very basic, but it gives us the idea. So number 7 says a theater or hotel would be classified under real estate category of. A says residential. Shake your head yes or no. Would a theater be considered residential? No, so I would call that false. All right. A theater or hotel will be classified under the category of. B says commercial. Could theater fall under commercial? Well, I do like that answer, but I'm not going to put that down just yet until I read C or D and make sure I don't have a better answer. So don't just stop at A or B when you think you have the answer. You guys with me? Because maybe C or D, you guys need to read every answer choice. So now we look at C. Theater would be considered agricultural. Nah, I'm going to call that false. Theater would be considered industrial. Nah, I'm not. I'm going to call that false as well. So now we've determined A, C, and D are false, which means our answer is B, commercial. So we broke that thing apart, didn't it? We dissected it. Now, guys, you're not going to have time to do that to every single question on the test. But again, we're starting to form these study habits, and in forming these study habits, we're starting to learn how to interpret these test questions. And mastering that is going to be a big step to get you guys through the test. Ezra Lou, let me come back to that, if you will. I'll get back to you on that. Another type of question that you may see, still on page 17, is number 9. And number 9 throws some Roman numerals in there for us. We have Roman numeral 1, Roman numeral 2. Again, read the question and then ask yourself, is Roman numeral 1 true or false? Is Roman numeral 2 true or false? In a sense, those are your answer choices. We're trying to determine which one of Roman numeral 1 or 2 is true or false. So number 9 says the designation realtor refers to any licensed real estate broker. Do your head one way or another. Is that true or false? That is, I'm seeing no's. So Roman numeral 1, we determine is false. Now hang on. Before we move on to 2, can't I automatically eliminate A and C? Because I've already determined 1 is false. So poof, just like that, I went from a 25% chance of getting it right to a 50% chance of getting it right. Do we like those Vegas odds better? So just by asking ourselves, just by focus on Roman numeral 1, now we know we're left to B to D, B or D. The designation realtor refers to an active member of the National Association of Realtors. What do you guys think? Yes or no? Roman numeral 2. I would agree. So what's our answer? Our answer is B. Again, you guys, if you will, the reason we give you all these practice questions is to help prepare you guys to be able to read these things and get you through the exam. So you got your book, which we're going to look at some more. You got the online learning system. Do we all get signed up for the online learning system? Everybody get registered? I was hoping to see more hands than that. Okay, all right, good. There we go. There we go. Okay, if you haven't done it yet, please make that a priority before, like, tomorrow, right? Don't do it now because I would consider that a distraction. But if you haven't gotten signed up yet, and if you are having problems, remember you can reach out to Jane. So is my internet connection off? Can you guys hear me? Okay, am I? Okay. All right. Another suggestion I have for you guys, when you're doing the quizzes in the book, now you can't necessarily do this in the online learning system, but when you're doing the quizzes in the book, I would like you guys to start working with a clock, because both of your exams are timed. And if you don't practice now with a clock, you don't know if you're leaving a whole bunch of time on the table or if you need to speed it up. So when you guys are doing these quizzes in the book, I suggest you set a timer. So, and I would say about 2 minutes per question, give or take. I think that's fair, about 2 minutes. So if you were sitting down right now to do the quiz at the end of Unit 1, and you were to set a timer, there's 20 questions, we said 2 minutes. So set the timer on your phone for 40 minutes. If you blow through it in 10 minutes and fail, you got time to slow down. If it takes you 45 minutes to do it, you got to pick up the pace a bit. But both your exams, mine and the state exam, are timed, and we'll talk more about that time, of course. But again, we're trying to form some study habits now. My whole job is to prepare you for the state exam. And reading and interpreting and dissecting these dang test questions is part of preparing you for that exam. And, I understand that a clock can put some pressure on us. So that's why I encourage you to start today. Now, the reason I said you couldn't do that in the online learning system is because you got the explanations in the online learning system. So that one, you're not trying to get through as fast as you possibly can. You want to learn the material, engage the material. So just the book would work. Any kind of flat, there's a couple flat PDF quizzes in the online learning system as well too. So you can just set a clock. Do I have any questions? Comments?
Can you retake the ones on the online system? Or
Yes.
did they?
Nope. Yep. You can go over and over and over again. And thank you for that, Katrina. And same thing with your book. Remember, we're not answering the questions in our book. So that way we're leaving that blank and we can take those again as well. Good question. Thank you. Anybody else? I do have a quick question for you guys. Somebody logged in last class. I pull a Zoom log after each class. It's like Big Brother. I know what time you guys log in. I know what time you guys log out. I got you. But I pulled my report from the last class and somebody was on as D. Snyder. If that's you, please send me a private message right now so I can make sure I count you. Please send me a private message. I'm not going to remember that 4 hours from now. So please send me a private message so I can make sure that I get your time. Thank you. Mystery solved.
I'm sorry, what was that? A private message for what?
I'm sorry?
What was that? To send your private message saying what?
If you were D. Snyder, if you logged on as the name D. Snyder, I think I found, I just need, if you'll do it in the chat, please. So getting back into unit 2 where we left off, and let's start with a review of where we left off. So if you guys will remember, we left off talking about estates. I want you guys now to set your chat to a private chat just to me. So go ahead and find your chat. And in a private chat just to me, this is just between me and you. When I say the word estate, what's the one word that comes to your mind? One word. When we talk about an estate, what's the one word that we're using to describe and define an estate? And again, this is just to me. So when we talk about an estate, we're talking about the interest that one holds in the property, the interest. So an estate is an interest. And there are two types of estates. There's a leasehold estate, which is an estate of possession. You don't own the property, but you have the right to possess that. We can call that a tenant. We're going to talk about tenants and landlords in Unit 11. And then the other estate that we talked about the other day was a freehold estate. And your interest in a freehold estate is that of ownership. So if you guys will, let's turn to our books on page 29. And on 29, we have a handy dandy picture there that lists the different types of freehold estates. One of the first things we can do is divide our freehold estates into those that it can be inherited and those that cannot be inherited. We talked about first about our estates of inheritance. Fee simple absolute is the highest form of ownership. If you own property fee simple absolute, then you own it all. You own the land, the air above it, the subsurface beneath it. You can do what you want to, it's your property. 99.9% of the time, don't write that down, I just made that up. 99.9% of the time, that's what we're going to be dealing with, our fee simple absolute freehold estates. We also have some other estates, though, that you may encounter. And if we encounter them, then we need to know that we're probably going to get an attorney involved, because this got out of our realm. Guys, I only got a real estate license. That doesn't give me the ability to practice law, right? So knowing when to call an attorney or accountant or whomever is a big part of this class. So if you ever have the opportunity to do, for example, a fee simple defeasible. The fee simple defeasible estates, there's the two of them there, put a restriction on use. It's a deeded restriction on how you can use the property. We also talked about life estates. Life estates put a restriction on time. Life estates tell us how long you own the property. And particularly where we left off, we looked at our conventional life estate, which says you will own the property. You can do whatever you want to with it for as long as you're alive. Once you pass, that estate is either going to go back to the person that gave it to you. We call that person the grantor. If the grantor is no longer with us, then it will go to their heirs. Or at the end of that conventional life estate, if it doesn't go to the grantor, it will go on to a named third party. Again, it's got to be deeded. It's got to say, once the conventional life estates, this deed is to convey to, and it'll name the third party. We're going to talk a little bit more about that in just a second. The other life estate that you can't inherit is the marital life estate. And this is the scenario where somebody owns property and then gets married. And when that individual passes away that owned the property, their spouse is entitled to some of that estate. How much are they entitled to? It depends on how long you were married. So they'll break that up, they'll divvy that out. Again, we're going to talk about ownership in just a bit. So we'll talk about how people own property when they purchase it when they're married. So we got different forms there. So the marital life estate. And then the last life estate we talked about is our pour alter v, which means life of another, life for another. That's our measuring life. So you have the life tenant and you have the measuring life. The life tenant owns the property. They can do whatever they want to with it as long as the measuring life is alive. Once the measuring life passes away, then the property either goes back to the grantor or on to the named third party. I think with that, I like the example in your book on page 31. No, sorry, 33. Page 33. And this talks about Austin. He owns a fee simple title to the property. He conveys it, life estate, to his brother Carl for the life of Carl's daughter who has a major disability. Carl has the right to enjoy the ownership of the property and is the life tenant, but the daughter is the measuring life. Should the daughter die, Carl's estate will terminate, revert back to Austin or his heirs. The daughter has no present or future ownership. The daughter has no interest in the property. She's simply the measuring. She's the measuring, the yardstick. She's the one that determines how long Carl owns the property. Clearly, Uncle Austin wants a good, safe place for his niece. Yes. So how can he assure that? How can he guarantee that? He gives his brother a life estate and allows him to own the property for his niece's life. Again, anything other than fee simple absolute, we're going to need to get attorneys involved. This just got out of our realm really fast. Questions on that? That's kind of where we left off the other day. So picking back up in our PowerPoint, we're on page 33. And we've talked about life estates either going to the grantor or going back, or I'm sorry, either going back to the grantor or going on to a named third party. Well, in these cases, these people have names. The remainder man is the named third party. Again, the deed has to spell it out. The deed has to say, at the end of this life estate, the property will convey to the remainder man, the one that has the remainder interest. The reversionary interest is the grantor. When you guys see reversionary, do you see the word reverse? With a reversionary interest, it reverses back to the grantor or their heirs if the grantor is no longer with us. If the deed doesn't name anybody, the default's going to be to go back to the grantor, to reverse back to the grantor. So at the end of life estates, it's either going to go reverse back to the grantor or their heirs, or it's going to go on to the third party, the remainder man, the remainder interest. As we've mentioned, life estates have life tenants. They own the property. They can do anything they want to. Their only limitation is on time. So the life tenant, during the time that they own that property, they can earn a profit from it. They could put a tenant in there if they wanted to. They could profit from the land if they wanted to. They can use the resources on the property. They don't have to answer to anybody. They own it. Now they can't destroy it because remember, somebody else is standing in line waiting on this property. So they need to be careful not to destroy it and still maintain it. I think the example in your book talking about life tenants talks about, I don't know where it is right now, but it talks about the property having an orchard and the life tenant doesn't want to maintain the orchard, but the next in line to get it wants it. So we may have a bit of an issue here. The life tenant owns it, so they get to pay taxes. They get to pay homeowners insurance. They get to pay any special assessments. We're going to talk about taxes and special assessments in Unit 3. Probably start on that today. I got a whole unit dedicated to homeowners insurance. So we'll talk more about that when we get to Unit 13. If the life tenant destroys the property or allows it, doesn't maintain it, the future interest, the next one in line, could seek legal action. They could take them to court. Also with estates, just as a real quick kind of side note, we have something called a homestead. Again, this is a call your attorney. If you bump into one of these, this is just a legal life estate that's occupied as the family home. A lot of time homesteads are protected from creditors. Now they still have to pay taxes, but they may have some exemptions from some of their creditors. There's a certain level of protection. If you want to know more about this, it's on page 34. This is as much as we're going to say about it, though. Again, if you bump into one of these, CYA, call your attorney. Let's see, Martha, I'm not sure if you can hear me, but it looks like your camera is off.
Found it. I can hear you. I'm not the best at these computers.
That's all right. We're getting there, right? Let's see.
Yes. I don't know how to.
If you move your mouse,
Yeah.
do you see like at the left, you can mute and unmute, and then right next to that,
Yeah.
it says start and stop video.
Yeah. Do I press that?
Yes.
Now, do you see me?
There's that white screen again. We just got a white, all we see is like a white light or something.
Can you see my hand?
Nope. Why don't you get with Jane? Why don't you shoot Jane an email tomorrow or later this afternoon? And see if
Jane?
she can't, and see if she can't troubleshoot with you. Her email's in the email from Lane.
Okay.
She
Thank
can
you.
probably troubleshoot with you.
Thank you.
So we're going to switch gears just a bit. And we just finished up talking about estates. And we said an estate tells us the interest that somebody has in a property. So in addition to an interest, we also have different forms of ownership. So the estate tells you the interest you have. The forms of ownership tells you maybe what percentage you own the property, for example. And we got two types of ownership. We're going to talk about both of these, of course. So there's ownership and severalty, and then there's concurrent. So let's start with severalty. Ownership and severalty is a sole owner. It's either an individual person or an individual entity. There is only one owner, and that one owner owns 100%. Then we have concurrent forms of ownership. Concurrent forms of ownership could be 2 owners, could be 3, could be 5, could be 20, could be 200. With a concurrent form of ownership, you have more than one person or more than one entity that owns the property. And we have several different types of a concurrent form of ownership. So we got tenancy in common, joint tenancy, and tenancy by the entirety. And of course, we're going to talk about these and break them down. So first off, we have a tenancy in common. And usually in a tenancy in common, the ownership interests are unequal. I own 20%, you own 80%. We do not have equal shares. With a tenancy in common, everybody owns their ownership, their undivided interest. They can sell it. They can convey it. They don't need permission of the other owners. And upon the death of an owner as a tenant in common, their interest passes to their heirs. Now, remember what I said. This is definitely a CYA section. Call your attorney. So when the attorney is creating the tenancy in common, these are the kind of questions they're going to ask. When something happens to you, what heirs do you want to have this passed down? So tenancy in common, the interest passes to heirs. So if we look at a picture, we can see that 2 people buy a home as tenant in common. They buy it with their unequal shares of 60-40. When the owner 60% passes away, presumably in this case, they have 2 heirs. So that 60% interest is divvied between their heirs. Now we have 3 owners. We have 2 that own it 30%, and then the original owner that still owns 40%. So tenancy in common. The other type, another type of concurrent forms of ownership we have is joint tenancy. With joint tenancy, the interests are usually equal. We own it 50-50 or 25-25, 25-25. With joint tenancy, the owners must, you guys see my absolute words here? All joint tenants must purchase at the same time. They all have to show up at the same time to take ownership. They all have to be on the same deed. They take title at the same time. We're going to talk about ownership for married people in just a second. And we're going to see some similarities of ownership with married people and joint tenancy. And I think with joint tenancy, it's a good way for unmarried people to purchase property. So joint tenancy kind of mimics tenancy by the entirety. So we can kind of do a side-by-side comparison on the two. And really the big difference we're going to see is one, they're married, the other one, they're not. So joint tenancy equals shares. Everybody shows up at the same time. And with joint tenancy, we have something called right of survivorship. What right of survivorship says, if two people own property, person A and person B, two people own property, when something happens to one, their interest automatically goes to the other. So in joint tenants, we're not passing it down to our heirs. Right of survivorship says we're passing it down to the other owners. Right of survivorship. Now, this is where joint tenancy gets fun. If you see a question on joint tenancy in the national section of your exam, we know that the right of survivorship is automatic. If you get a joint tenancy question in the state specific section on your exam, in North Carolina, the right of survivorship has to be created. Again, we have attorneys involved. So in North Carolina, right of survivorship is not automatic. We can add it, but it's got to be intentionally created. So if we look at our picture, again, I got two people that buy 50-50. One of those owner dies, their ownership goes to the last man standing, who, guess what, now owns it in severalty. We went from a concurrent form of ownership to severalty. They severed the other owner. As I mentioned the other day, and I think it's important to bring this up again, particularly in this section. Yes, there are, well, hang on to that thought. I'm going to wait to say that. Never mind. So if we look at an example together, sister and brother purchase a beach cottage, taking title as joint tenants with the right of survivorship. The brother later dies. His interest in the beach cottage automatically passes to the sister, as she is now the surviving joint tenant, and she now owns the property in severalty. She's the last man standing, so she's the sole owner of that property. With joint tenancy, there's a couple requirements. Again, we just kind of touched on these a few minutes ago. In order to create a joint tenancy, we have to have the four unities. There's unity of possession, which is the right to possess the entire property. Just because you own 50% doesn't mean you can draw a line down the middle of the property and say, this is your half and this is my half. We still have the ownership, the interest of the whole property. Does anybody, when you were growing up, have to share a bedroom with your siblings? Anybody have siblings? See, okay, so I'm an only child, so I don't feel this pain. But some of you, I hear stories about sharing bedrooms with your siblings. You guys ever take something and draw a line down the middle of the room and say, this is my half of the room, don't come on it, this is your half on the room, I'm not going to come on it? You can't do that with joint tenancy. We have unity of possession. We have unity of interest, which means we have an equal interest, 50-50, for example. Unity of time, which says we all take property at the same time. We all show up at the attorney's office. We all take property all at the same time. And then unity of title. We're all on the same deed. Let's see, I got a couple questions in the chat. Let's go back and get these. If both die in joint tenant, what happens? So you got the brother and the sister, right? The brother died and it went to the sister. So when something happens to the sister, her will is going to dictate what happens to that property. Okay. What if the brother has kids? Right of survivorship says heirs don't matter. Right of survivorship says when you have two owners and one passes, it automatically goes to the remaining. Good questions. Again, we're getting ready to look at for married people. And I think it makes a little bit more sense when we talk about married people. If there's no will, then actually we're going to talk about what happens if there's no will when people pass away when we get to Unit 5. So hang on to that question for probably next week, and we'll talk about what happens if people die without a will. What happens to their property? See why I want you guys to get an attorney involved? This is some weird stuff. Something else about joint tenancy. Let's talk about this. And this tends to be a problem topic. So let's make sure we talk about this. I don't know. So the property is owned by 3 or more joint tenants, and one of them chooses to and is allowed to convey their interest. The new owner cannot come in as a joint tenant. They must come in as a tenant in common. Why? Remember our unities with joint tenancy. In order to be a joint tenant, everybody has to be there to take title at the same time. Everybody has to be on the same deed. So let's say we have a joint tenancy with 4 owners. And I'm going to get really creative, and I'm going to name my owners. We're going to call this one A. We're going to call this one B. This one is named C, and this one is named D. So I have 4 owners, all joint tenants. They all own 25%. They come in, they were all there at the same time, all taking title at the same time. So they are going to come in as joint tenants with each other. This is what joint tenancy looks like. We were all there, all at the same time, all taking title, we're all on the same deed. So let's say that B wakes up one day and B says, I've had it. I'm tired of you guys. I am done. I am going to sell my 25% to E. Now, whether or not they can sell is going to be drawn up when we create the joint tenancy by the attorney. So this is assuming that we've all agreed that we can sell. So B sells to E. Please shake your head, yes or no. Can E be a joint tenant with A, C, and D? Can E be a joint tenant? No, because E wasn't there on day one when we all took title. So E is going to come in not as a joint tenant with A, C, and D, but as a tenant in common. Somehow I need to get E and C are also tenant in common. A and C, C and D, A and D are still joint tenants. They're still the originals. But E cannot be in as a joint tenant. So now we get into what happens when these people start dying. What happens to their interest? My answer to you is call your attorney. This just got beyond our scope super fast. See why we want an attorney involved? What we need to understand, joint tenants all take title all at the same time. E owns his 25%, A owns their 25%, C owns their 25%, and D owns their 25%. E just bought B's 25%. Tricky, tricky. If you want to know more about this, sign up for law school. I would do one thing at a time, though. Don't sign up for law school until you get your real estate license, okay? One thing at a time. How joint tenancy and tenancy in common terminate. Again, they could voluntarily agree. The court could partition the property. The court could take the property. If A, C, D, and E start getting into legal battles, now we got the judge involved, and they could determine the outcome of anybody's ownership. Could B have sold it to A? That's a great question. Thank you. Could be have sold it to A if it was drawn up that way originally. Right? It's all in how it was created. And these are the kind of questions the attorney's going to ask to help create. So if we're originally and we're creating it, and A, B, C, and D say, yeah, they can sell it. Yeah, they can even sell it to each other. Then yes, it's allowed. And then E, B sold their 25% to E. Yes. So now E owns B's 25%. So tenancy in common and joint tenancy are set aside typically for people that purchase property that when they purchase, they are unmarried. Everybody with me? Tenancy in common, joint tenancy. Unmarried people purchasing property. So when married people purchase property, they're going to purchase as tenancy by the entirety. This is important, you guys. In order to be tenants by the entirety, you have to be married when you purchase. In order to be a tenancy by the entirety, you have got to be legally married when you purchase. Separated is married. Engaged is not. There's really only two answers to the question, are you married? Either you're married or you're not. And if you're married at the time you take title, the default will be tenancy by the entirety. Married people can choose to do joint tenancy or tenancy in common. They can choose, but the default. And in order for married people, tenancy by the entirety, to convey their property, both of them have got to sign the deed to convey it. Both of them have got to be on board to sell it. North Carolina is known as what's called a spousal state. In North Carolina, to convey property, both spouses, even if they're not on the deed, both spouses have to sign to convey. North Carolina, 1 to buy, 2 to sell. I took pre-licensing in 2008. And the story about this I heard from my instructor stuck with me. Obviously, here we are all these years later, and I'm still sharing it. So the story I heard when I took pre-licensing, 1 to buy, 2 to sell. You got a married couple. Gentleman purchases a condo for his mistress. That relationship runs its course. He goes to sell the condo. What's the attorney say? Your wife has to sign up to show the property too. Gentleman says, uh-oh. He's got 2 choices. He either fesses up and tells his wife he bought a condo for his mistress and now he wants to sell it. Or I guess he finds a tenant. I don't know, but he's kind of stuck at this point, isn't he? North Carolina is a spousal state. The wife didn't have to be there to help him buy it, but she had to be there when he sold it. I guess the moral to this story is rent an apartment for your mistress. Don't purchase property. No, that's not the moral. Don't have a mistress. Okay, all right. Or a mister, let's be fair here. 1 to buy, 2 to sell. With tenancy by
sorry.
yeah.
I'm sorry. I didn't want to interrupt, but I want to make sure that I understand. So you're telling me that if I go buy property, even though my husband has nothing to do with me buying the property, in order to sell my property, he has to agree
To sell it.
To sell it, even
1
if
to
I
buy,
buy
1 to buy, 2 to sell.
2 to
Got
sell.
it.
Great.
Again, you guys, this is what I said the other day. Thank you, Kimberly. This reminded me. This is what I said the other day. Are there such a thing as a prenup? Is there such a thing as, could the husband and wife agree to something with an attorney? Of course, but guys, we're not getting into prenups and we're not getting into all that. Okay, we're just focusing on the very basics here of this tenancy by the entirety. So could you get married with a prenup that says anything we buy after this marriage will remain mine? Sure. Could you say, I want to buy this property, I don't want my husband to get anything? Sure. You need to get an attorney involved. This just got way beyond our scope. So with Tennessee by the entirety, right of
Excuse me.
survivorship is yeah.
I have a quick question. So what happens if you are not married and you buy a property and then you get married?
Hang
What?
on to that just for 1 second. We're going to talk about that. Yep. Bear with me here. Okay. So with Tennessee by the entirety, right of survivorship is automatic. Remember what we said about right of survivorship? You have two people that own, you have two married people that own. Something happens to one, the interest automatically goes to the other spouse. Also with Tennessee by the entirety, we have unity of possession, interest, time, and title, the same four unities we saw with joint Tennessee. And how we terminate Tennessee by the entirety, death of one spouse will terminate the Tennessee by the entirety. The remaining spouse now owns it in severalty. Divorce could terminate the Tennessee by the entirety. It depends on the attorney or the judge's divorce decree. Maybe we sell it and split the property. Maybe one of us is going to get the property, which will be redeeded from us to me. Or a mutual agreement, which means we can both agree to sell it. So the question that just came in, what if I buy property and then I get married? Please understand, the act of getting married does not create a Tennessee by the entirety. So if you own property and then you get married, your spouse only comes in as a spousal interest. Remember, we talked about that marital life estate. So as the spouse in the marital life estate, your spouse, when the original owner passes away, that spouse will be entitled to something. How much? The marital life estate says it depends on how long we were married. But I need you guys to hear me when we say the act of getting married does not create a Tennessee by the entirety. In order to take Tennessee by the entirety, you have to be married when you take title. When you get married, you could create a Tennessee by the entirety. You could go to the attorney's office and create. And I'll share with you guys, when I was younger, I bought a condo. I didn't even know my husband at this point, but I was done with the roommate thing. So, I bought a condo and said, I want control over this thing. Then I found my husband, we got married. When we got married, the only interest he had to that condo was a marital life estate. Once we got married, I created a Tennessee by the entirety. And how did I create that? I deeded it from me to us. And the reason I did that is if something happens to me, I don't want him to, he's already sad enough, right? So I don't want him to have to go through any more legalities than what he has to. But again, that's not required. Please understand, that's just something we chose to do. But we had to purposely create it. We had to go to an attorney and have that deeded, have that created. It did not happen automatically. So while engaged, if you're engaged, are you married? Shake your head, yes or no. If you're engaged, you're close, but you're not married yet. So while engaged, Tom and Nancy purchased a home in Walkertown. They were both named as grantees on the deed. They get married 1 month later. Their marriage does not convert ownership of the home into a Tennessee by the entirety because they were not legally married when they took title. With both their names being on the deed before they were married, they're either on there as a joint tenant or a tenancy in common. I think in practice, when you're working with married buyers, helping them buy, again, Tennessee by the entirety is the default. But if you ever work with an unmarried couple, this is when we need to advise them to talk to their attorney. Guys, I cannot tell somebody how to legally take title. Just because I have a real estate license doesn't give me the right to tell them how they can legally take title. I had buyers a couple years ago. And they were unmarried. They just moved down from New York. He came down here for a job and she took, chance and came down with him. And he said, I'll either get you the ring or I'll get you the house. And she said, oh, I want the house, no question. So they moved to North Carolina. They bought a house together. I knew they were unmarried. I did not whip out my pre-licensing textbook and proceed to explain joint tenancy and tenancy in common to them, because that's giving legal advice. So what did I do? I set them up with a conference call with their closing attorney. It was probably a 5-10 minute call on their lunch breaks. And while I wasn't part of the call, I'm pretty sure the question the attorney had, the number one question the attorney had for this unmarried couple was, if something happens to one of you, what do you want to have happen to your interest? If you want it to be passed down to your heirs, we're going to do tenancy in common. If you want it to go to the remaining owner, we'll do joint tenants. And that's why I think joint tenancy and tenancy by the entirety are parallel. The big difference between the two, tenancy by the entirety is married, joint tenancy is not. So please make sure you stay in your lane and know, particularly when you're working with unmarried people, it's probably a good opportunity to have them talk to their attorney so their attorney can explain. A question comes in, how do you know when to send someone to a closing attorney, or do you always need an attorney? Not always, but that's a good thing about our real estate transactions is we have an attorney involved anyway. North Carolina is an attorney closed state. So we can make recommendations, of course. They may come with their own attorney. We're going to talk about, we get to go to closing in Unit 21. Unit 21 is like my favorite because I love closing day. Closing day is a good day. So Unit 21, we'll get to go to closing. We'll talk about how we handle closing in North Carolina, how that process. So what I have for you is, you guys don't need to write this down. Just hang on for a second. This is just a kind of a nice little chart that breaks down side-by-side comparison of joint tenancy, tenancy in common, and tenancy by the entirety. I have this for you in the online learning system. So this is screenshot, this PowerPoint. So you don't have to write down because we're recording. You have all of my PowerPoints, but I've pulled this one slide out and made its own separate thing, and it's in the Unit 2 material of the online learning system. And I think this is where when it's going to be helpful is 2 months from now when you're reviewing everything. Remember that this chart's in that Unit 2, and that would be a great opportunity for you to come back and review it and get that summary. Question comes in, can you get around this by having an LLC to buy and sell? Call your attorney. I honestly do not know the answer to that. So if you create an LLC, how that works, yeah, we need to get way beyond our scope. So an estate is the interest that you have. And then we have to determine the different forms of ownership. Do you own it in severalty, or are you a concurrent, 2 or more? Questions? Do y'all know the KISS philosophy? KISS, keep it simple, sweetie. And that's exactly what we're doing here. Keep it simple. Okay, let's go ahead and take our first break. And when we come back, we're going to talk about some concurrent forms of ownership. And we're back. All right, cameras are on and I can see you. Please always remember it's twofold. So I am taking our screenshot for attendance. And up next, we're going to switch gears just a bit. We've talked about estates. We've talked about ownership. There's, like I said, there's just some weird stuff in Unit 2. And thank you for telling me that you're back from break, so I can make sure I count you here. The last little section of Unit 2 is about common interest communities, also known as hybrid forms of ownership. And the reason, Brian, if you will, please tell me in the chat that you're here. We missed a screenshot. So the reason they're considered, thank you, the reason they're considered hybrid is because they have two different forms of ownership. So while you generally have somebody that owns a form of property either in severalty or concurrently, but you also may have an owners association that may have some ownership as well. So we got a couple different types of ownership going on here. And the first hybrid form of ownership that we have, common interest, is condominium ownership, also known as condos. Condo owners own airspace. Condo owners own from sheetrock to sheetrock, or paint to paint, or wall to wall. Condo owners don't own anything on the exterior. Condo owners don't own land. They don't own the air above it. They only own airspace. This is why we can stack condos. This is why we can have a 10-story condominium. The individual owner of the unit only owns that airspace. Condos, thank you. Condos also have known as something as a common area. Why don't you guys tell everybody in a chat, what are some examples, when I say common area, what are some examples that come to your mind? Examples of a common area. The lobby, elevator, gym, pool. Yep, the pool. Hallways, breezeways, parking lot. There's a good one. Laundry area. Elevator. Any of the landscaping. There you go. Maybe the street sign. Clubhouses, parks, playgrounds. So we get the idea, right? Common areas, once you own in this ownership, once you own in this condo, then you have access to these common areas. The common areas are managed by the homeowners association. That's what HOA means, homeowners association. Again, we're going to talk more about HOAs when we get into Unit 6, I think. The owners of the condo own the common areas as tenants in common. So they not only own their individual unit, but they also own tenants in common, the common areas, as tenants in common with the other owners. That they pay for, you betcha. Usually an assessment or part of your HOA dues. Condo owners may also have access to limited common areas. So for example, you might have an assigned parking space. Maybe you have like a storage unit or a garage. So you have exclusive rights in some cases. And when it comes to condos in North Carolina, we have something called the North Carolina Condominium Act of 1986. And what the Condominium Act says, it does a few things. The developer of the condominium has to provide a final plat map, a final plan, bylaws, rules, covenants, all that needs to be finalized before they can close on the first unit. So you're building a new condo complex. Before you can close, before you sold the first unit, we have to have everything finalized. We can go under contract with preliminary. If there's any major changes to the preliminary, then the buyer needs to be shared that information and have the right to terminate. So we can be under contract with preliminary, but before we close on the first unit. The Condominium Act also says that the developer should provide their public offering statement. This is just a statement that discloses ownership, like how's it structured, management. Other important docs, like we mentioned, restrictive covenants, bylaws. The buyer should have access to that before they sign their contract, before we go under contract. The other thing that the Condominium Act does is it allows the buyer of a new construction a 7-day recession period. So what's a recession period? In a recession period, you have this opportunity, in this case, 7 days, to rescind your contract, which means you can take it back. If you put down any deposits, you'll get your money back. When you rescind a contract, you take it back, you get your money back. Both parties go about their lives as if this contract never happened. It's totally erased. Everybody's made whole again. And for new construction condominiums, the buyer has a 7-day recession period. They have 7 days. This is to try to prevent the shady developer from taking advantage of buyers. So they have the 7 days to decide if they want to rescind their contract, get their deposits back. This 7-day does not apply to resale. So once the developer sells a unit to the first buyer, when that person sells, it's a resale. It's only the first sale from the developer that you get that 7 days. Resales, we still need to have the information. A buyer always deserves to know what they're buying. So we still should be provided with covenants and bylaws, and the resale certificate talks about ownership, how's it structured, management, etc. And again, with a condo, with a resale condominium, there is no right to rescind your contract. Now we're going to get into contracts in Unit 10. We're going to talk about buyer's rights to terminate, the contract to closing process. We'll get into that in this class, what all happens from the day we go into contract to the day we close. There's a lot that goes on. And we're getting there. Somebody asked about payment. Yeah, with condos, you're going to have an HOA. They're going to have either monthly dues, quarterly dues, annual dues. I think it's important that we understand very early that all HOAs are different. They're all managed different. They're all structured different. And that's a big reason why the North Carolina Condominium Act helps regulate that and make sure that the buyers get the information they need. Another form of hybrid ownership, common interest ownership, is something called a cooperative ownership, also known as a co-op. With a co-op, you do not own property. With a co-op, you purchase stock. And by purchasing stock, that gives you the right to live there, proprietary lease, there it is, that's hard. Proprietary lease is the right to live there. So the building is held, land is held and managed and structured by corporation. You purchase stock, that stock gives you permission to live in that unit. We don't see many of these here in North Carolina. I've heard of like one in Charlotte, but I don't remember the name of it. We see these more in bigger, older cities. So think like New York, Philadelphia, Boston. This is where we see co-ops a lot more. Another form of common interest ownership are townhomes. Townhomes differ from condos. A couple of differences between the two. First off, what you own with a townhome is different than a condo. Remember, with a condo, you said you just own airspace, wall to wall, paint to paint. With a condo, you own the unit, but you also own the air above it and the land. You know, condos like here, you can see this driveway and this little patch of land right here. That's yours. And out back of the townhome, you probably have like a little pad or a patio or something. That's yours as well. So townhome owners own a little bit of land. A common feature of a townhome is that they're sometimes called row houses because they're side by side by side. And they share what's referred to as a party wall. So you see, I got an owner here, you got a front door here, and I got a front door here. You guys see this? This wall right here is what divvies the two. That's their party wall. They're also regulated by an HOA. In a townhome, the common areas are owned and managed by the HOA. Remember, in the condo, we said that they're managed by the HOA, they're owned as tenants in common. So again, there's another difference between townhome and condo. Townhome, they're owned and managed by the HOA. And townhomes are not covered under the North Carolina Condominium Act because they're not condos, they're townhomes. Again, the big difference between the two: townhome owns land, condo does not. Townhome owns and manages the common areas by the HOA. In a condo, the common areas are managed by the HOA, but they're owned by the people that live there as tenants in common. Another form of common interest or hybrid form of ownership are timeshares. A timeshare, if you have a timeshare, you own a unit. But with a timeshare, you only have the right to occupy that unit during a certain period of time. So let's say, for example, you purchase a timeshare and you own that unit for 1 week out of the year. 51 other people have the right to occupy that the other weeks of the year. So you're sharing, and what you're splitting up is that time. And the definition of the timeshare is the right to occupy at least 5 or more separate time periods over at least 5 years. I want you guys to please note, 5 is the minimum. So as long as you own it for at least 5 or more separate time periods over at least 5 years, then it qualifies as a timeshare. And guys, if it fits this basic definition, it doesn't matter what it's called. It doesn't matter if you call it, Eastern Resort Vacation Spot. If it fits this definition, it falls under the timeshare ownership. I say, if it walks like a duck and quacks like a duck, it's probably a timeshare. So as long as it fits this definition, With timeshare ownership, owners or buyers that go under contract have a 5-day recession period. So we go under contract, the buyer has 5 days to rescind their contract, take it back, pretend like it doesn't exist. An example of a timeshare, so you may have something down at the beach, for example, and there's the community, and you purchase a timeshare, and they say, your week in this timeshare every year is June 1st to June 7th. And that's the time that you have to occupy that unit. You can't show up on May 31st. You can't show up on June 8th. Your week is June 1st to June 7th. That's what you own, is the right to occupy that week. The other rule we have for timeshares is how the developer handles the deposit. So we go under contract, the buyer puts a deposit down, and the developer is required to put it in something called an escrow account, also known as a trust account. We're going to talk about the trust account and the escrow account. We're going to talk about a lot throughout this class. This is your first introduction of the trust account or the escrow account. What we need to understand about this right now is that when the buyer puts their deposit down, the developer must keep that deposit in their escrow account for 10 days. If the buyer rescinds, the developer reimburses them. They give them their money back. If the buyer doesn't, the developer can transfer this money from their trust account to their operating account. But basically, they cannot touch that money for 10 days. Once in a year only, Vina says, yeah, and you know, they're all different. So I think the most common timeshare we see is you get 1 week out of the year, but you know, there could be one where you get 2 weeks, maybe you get, right? So they're all developed, designed a little bit different. Again, you guys, the purpose of these rules is to prevent the shady timeshare developer from taking advantage of the buyer. Now, it's not an Airbnb, because remember, to be a timeshare, you have to occupy it at least 5 or more separate time periods, which means you can't just go once, you have to go at least 5 times, and that 5 times has to be at least over 5 years. And if you call it Julie's Airbnb and it meets this definition, it falls under the Timeshare Act. If it walks like a duck and quacks like a duck, it's a timeshare. So you can't try to call it something else to trick people, right? If it meets this definition. So I'm going to stop sharing just for 1 second. Well, then you guys don't see it. Okay, so pull back from your computer a little bit. Give yourself some room, because I don't want you to hurt yourself or anything else. So one way we have to remember what we need to know about a timeshare. What do we need to know about a timeshare? And it's exactly what you're looking at. 5, 5, 5, 10. Let's do all that together. You guys ready? What do we need to know about a timeshare? 5, 5, 5, 10. And let's have fun and throw in some jazz hands, because, you know, why not? You're not going to be tested on jazz hands, but what the heck, right? So what do we need to know about a timeshare? 5, 5, 5, 10, jazz hands. Okay. Now, obviously, we need to know what that 5, 5, 5, 10 is. But this is the very basic definition of the Timeshare Ownership Timeshare Act that regulates how timeshares in North Carolina. Again, remember, the Real Estate Commission's main purpose is to protect the public. And some timeshares in the past don't have the best reputation for having the public's best interest. So this is the commission's way to step in and make sure that their public is protected, even when they're purchasing a timeshare. The other thing we need to know about a timeshare. The Real Estate Commission has the ability to fine a timeshare developer. And commission rule says that they can fine a timeshare developer up to $500 per violation. What makes this unique? This is the only situation that the Real Estate Commission can fine a licensee. The only time you can get fined by the Real Estate Commission is if you're a timeshare developer. If you're not a timeshare developer, the only thing the commission can do is discipline your license. We're going to talk about the disciplinary process, what could or could not happen to you. We'll get all of that in Unit 7. But this is the only time that the commission is going to get involved with matters of money, is for a timeshare developer. We're going to spend a little bit more time in the Timeshare Act. It's probably like the last thing we talk about. Isn't this funny? Timeshares are kind of our bookends. So we're going to, introduce it to you now. And then one of the last things we talk about is the Timeshare Act. So we'll see this again. And we'll get to do our 5, 5, 10, 10 jazz hands again too. Good times, huh? Oh yeah. All right. Questions on our common interest properties or hybrid forms of ownership? The last little piece of Unit 2 is talking about trusts. Trust is in a way to, if you don't want your estate, your interest to go through a will and probate after you pass, you could set all your interests up, your property and whatever assets you have in a trust. Just again, a way of estate planning. It's to my understanding that probate can get lengthy and costly and in some cases kind of nasty. So if you want to make sure your family's not fighting over your estate after you go, you may want to consider talking to an attorney about a trust. And with a trust, there are 3 parties. So the grantor is the person that owns the trust. The person that once they pass away, we need to do something with their estate. The trustee is the impartial third party that's going to handle it after the grantor passes. The trustee is going to be an attorney. And the trustee is going to manage it for the benefit of the beneficiary. The beneficiary is the person named in the trust that's going to get the estate after the grantor passes away. Again, it's just a legal process to maybe avoid probate. If you're interested in more of this, call your attorney. If we as real estate agents are ever called to get involved in a trust, maybe help the family, the beneficiary sell it, for example, we're going to be dealing with the trustee anyway. We're going to be communicating with and dealing with the attorney. So we already got one involved. And that gets us through Unit 2. So again, when we finish up a unit, I like to remind you the key terms that are at the beginning of the unit. Use these key terms kind of like a checklist. Do you know what this word means? Do you know what that word means? Guys, I'm very serious when I say that it all starts with just the basic, know what the word means. So please pay attention to those key terms. If you're not sure of it, if you're not comfortable with it yet, if you can't recite it back, then you make a flashcard out of it. But please do not try to make a flashcard out of every single key term in this book. You will be overwhelmed by flashcards. The end of Unit 2 on page 43, you have that key point review, kind of your summary. Use it as a checklist. I know what this means. I know what that means. I'm not sure about this. Let me go back and look it up. And then you got your student quiz on page 47. Questions? I need to stop sharing this for 1 second. So if you will just bear with me. And what we're going to do next is kind of an introduction to the math, some of the math. We don't actually start getting into math until the end of Unit 3. So we're not going to get to that today. But we'll see that next week. But before we get to that, I just want to introduce you just to some ideas, some things to help you guys work through as we start the math next week. So first off, did everybody go calculator shopping? Or better yet, did anybody go calculator shopping? Do we have our basic calculators yet? If you do, please go ahead and grab it. We're going to start using it. If you haven't gotten it yet, that's okay. Just please get it this weekend. Like I said, I want you guys to get this as soon as you can so you can start practicing on this. Guys, the calculator on your phone is smart. This one, not so much. So I don't want you doing the practice math here and pick this one up on test day and think you got this. Everybody with me? This one is a lot smarter than this one. So please get this one now or this weekend so you can start practicing with it. And you can take that out of your guesswork on the test day. Back in the day when we were in person, it was not uncommon for somebody to show up on test day and ask me how to work their calculator. And that sent a little pang of nerves through me. I mean, I can't imagine what that did for the person that woke up on test day and didn't realize they didn't know how to work a calculator. So get your calculator and learn how to work it. Fair enough. Can I get some thumbs ups? Okay. Trying to eliminate all the stress we can on test day. So here's our little introduction, just to some math. We're not actually going to get any real estate math today, but we're just going to have a little introduction so we know we're prepared for next week. Remember too, you got that math facts section in the back of the book. I don't remember the page off the top of my head, but there's a math facts section. I don't think you guys should spend all your weekend study time on that math facts section, but I think it's worth kind of flipping through and just exposing yourself to the stuff that's back there. So here's the good news in this class. We only use 5 keys: add, subtract, multiply, divide, and percent. We're not getting into exponents and parentheses, right? All that other stuff. So we're trying to keep this simple, which is another reason why we have a very basic calculator. And first, let's make sure we understand what we're talking about when we talk about a percent. A percent just means per 100. So in other words, with a percent, if I tell you 5% of the homes on this street are yellow, that just means out of every home, out of every 100 home, 5 of them is going to be yellow. That's all we're saying. 5% are yellow. So how many out of 100? 5. 5 are going to be yellow. I do math tutoring as well. And I've been doing that, gosh, I think this is like year 12 or something of doing some math tutoring. And probably one of the biggest things I hear from you guys in math tutoring is learning how to read the problem and interpret and translate that into math. The truth is we don't read math, do we? We do math. So here we are giving you a test question and expecting you to take that and dissect it and turn it into a math problem. That's things that I can hope to help you guys work through as we go. But for right now, I just want to kind of introduce you to the idea that when you see the word of in a math problem, I'm telling you to multiply. So when you see that word of, we know that we're going to multiply something. So for example, 350,000 times 25% is the exact same thing as saying 25% of $350,000. What's that word of mean? Means we're going to take 25% times 300, or on your not so smart calculator, you're actually going to take 350,000 times 25%. So why don't you guys in a private chat, now bear with me a second. Anytime we do math, every time we do math, I always ask you guys to respond in a private chat. And that's two reasons. One, I fear some of you are so worried about getting it wrong that you don't want to do it. That doesn't help you for your test, you guys. So when you tell me in a private chat what your answer is, this is just between me and you. I'm not going to share your answer with the class. So you tell me in a private chat, I don't care if you get it right or wrong. I want you to learn from your mistakes. I want you to work the kink out so we can prepare you for test day. The second reason I ask for private chat with math is because I also know that some of you, if everybody put their answer into everybody, some of you will sit there and think, oh, well, everybody else is saying C, so that's my answer too. And you've never picked up a calculator. And again, I ask you, how does that prepare you for the exam? So private chat is always going to be, I'm sorry, math is always going to be private chat. So everybody go ahead and set your chat just to me. And I would like all of you, and I want to hear from all of you. This is that class participation we were talking about. Tell me in a private chat, what is 25% of $350,000? And I'm hearing from all of you. Okay, we all in? So we see the word of, don't think about it. When you see the word of, you know you got to multiply something. You may not know what to multiply at this point, but you know when you see of, you got to multiply something. So in this case, what we're saying, 25% of 350,000 on your not so smart calculator, you're going to say 350,000 times 25% equals, and your calculator is going to tell you it's 87,500. You could also say 350,000 times 0.25, and get the same answer. If you don't want to use the percent key, you got to move the decimal point. And quite frankly, here's the deal with math, you guys. It's not going to take you long to learn that I'm a big math nerd. Man, I wish we had more math on this test than what we do. I know that's not the popular opinion. If we were in person, I'd probably just gotten rotten tomatoes thrown at me. So I'm protected by my computer screen. But one of the things that I like so much about math is that all of our brains see it differently. I need you guys to find your way. Do you like the 25%? Do you like the 0.25? It makes no difference to me which one you use. I suggest you be consistent with yourself. Don't toggle back and forth, right? Pick one and stick with it and use that to practice. All of your math, all of your test questions, for that matter, are multiple choice, A, B, C, or D, which means the answer to the math, to that math question is looking at you. It's just a matter of figuring out, is it A, B, C, or D? I don't care how you get to the right answer. Makes no difference to me how you get to the right answer. Just get to the right answer. Back in the day when we were in person, I used to use the example of, let's go to the mall. Let's say we all jump up from our desks right now and we all run to the mall. I don't know where you're located, but I think it's safe to say, is there more than one way to get to the mall? Is there more than one route you can take? Some of you will go the fast route and jump on the highway. Some of you want to take the back roads to get to the mall. Some of you will take a dead end and have to turn around and come back and start all over. None of that matters as long as you get to the mall. I don't care how you get there, just get there. When we do the math, I try to give you guys a couple different ways to see it. If you find a way to work that works for you, that's not what we're doing in class, perfect, do it. So another private chat question. I would like you guys to first read the problem and then tell me in a private chat what your answer is. Okay, we all in? So the first thing I want you guys to do when you read a math problem, or any problem for that matter, but particularly math, the first thing I want you to do when you see a math problem is just read it. Put your pencil down, sit on your hands if you have to. So many times we see math and we want to immediately pick our calculator up, start doing something. Don't do that. Just read the problem. So we see a math problem and it says, Lane sells her home for $250,000 and pays her real estate agent's firm a commission of 5% of the sales price. What is the total commission paid? The formula that we need is right here in this problem. We're telling you that it's 5% of what? Of the sales price. And what does that word of mean? It means to multiply. So on your calculator, you said 250,000 times 5% or 0.05, whichever you like. And that means we got Lane a commission, or Lane's firm a commission of $12,500. 250,000 times 5%. We're going to talk about your commission, how and when you're paid. We're even going to talk about how you can calculate your commission when we get to Unit 8. So that gives you some, that's fun math. Y'all blow my mind. You guys sit and say, I can't do math. But I tell you what, when it comes to calculating your commission, that's a different story now, isn't it? So we'll absolutely get in more in your commission, etc. once we get into Unit 8. So as we start getting in this math in Unit 3, I'm going to introduce you to a tool. And this is like my favorite piece of this tool. This is something called the T-bar. So I would like you guys first, just take a minute and please write this down. Don't take more than a minute, but just take a minute and write this down real quick. And then we're going to talk about what this means. So this is something called the T-bar. And if we understand the T-bar, this is something we can use in a good chunk of this math in this class. Not all of it. Sometimes we do just need to memorize the formula. But a lot of times, if we can understand the T-bar, then that can get us through most of this math. The reason this is called the T-bar is because the formula itself makes the T. You guys see that? And with the T-bar, there's three variables. There's something called the part, there's something called the whole, and there's something called the percent or rate. Most of the time, not all the time, but most of the time, when you're reading a math problem and you see percent or rate, most of the time we can use a T-bar. The back fourth line of the T-bar, the horizontal line, the east-west line, I don't care what you want to call it. This line right here is our divide by line. The up-down line or north-south line or vertical line, whatever, is our multiply line. So when we look at the T-bar, actually what the T-bar gives us is three formulas. If my X, if my unknown is the number on top is the part, then in order to solve for the part, I'm going to take the whole times the percent. If my unknown or my X is the whole, then I'm going to take the part, divide it by the percent. If my unknown is the percent, then I'm going to take the part and divide it by the whole. The rate or percent always goes in the bottom right. Did you just hear that absolute word I threw at you? The rate or percent always goes in the bottom right. You guys shouldn't have to think about that. When you're setting up a T-bar, the rate or percent always goes where? Julie says it goes in the bottom right. So now the last two variables, the part and the whole, are what we need to discuss. Generally speaking, for the most part, the part is the smaller number. So when you're looking inside what number goes on top, what number goes on bottom, for the most part, we do have one exception in this class that we will get to. But for the most part, the part is going to be the smaller number. So let's say, for example, let's say you read a problem and it tells you the commission percent is, I'm going to make some numbers up. Commission is 4%. The sales price is $100,000. And the question wants to know, what is your commission? So we've read the problem. We see the three pieces. I see a percent, I see a whole, and I see a part. I've read the problem. Most of the time when we see percent or rate, that tells us we can go ahead and throw down a T-bar. Julie says the rate or percent always goes where? Always. And the bottom right, y'all don't think about it. Put the rate or percent in the bottom right. That's where it goes. So now the next question is, does the sales price go on top or bottom? Does my X go on top or bottom? Which number is going to be bigger, your commission or the sales price? And I see your mouths move. Unfortunately for us, right, the bigger number of the two is going to be the sales price, which means the smaller number of our commission is our X that we're solving for, and our sales price is the whole that we're going to put. No. So now that we've completed our T-bar, the last step is just to solve. And how do I solve for X? Well, my up-down line right here tells me to multiply. So I take 100,000 times 4%. Look at y'all typing your commission in. I hear you. 100,000 times 4% gives us a commission of $4,000. We read the problem, we set up the T-bar, and now all we have to do is multiply and solve for X. Here's another reason why I like the T-bar so much. My personal goal for every single class I've ever taught is to convert all of you to big fans of the T-bar. So by the time it's the end of the class, I'm going to have lots of you on board, or at least that's my goal. All of you is what I want. But this is another thing I like so much about the T-bar. Let's say you're in the throes of the test and test stress is a very real thing and you're feeling anxious and you read this problem and you say, oh my God, for the life of me, I cannot remember if sales price goes on top or sales price goes on bottom. I know the percent goes here because Julia's drilled that into our brains. So we know that's where that goes. Now the question is, what number goes on top and what number goes on bottom? My suggestion to you, if you don't remember, if you don't know, flip those numbers. Now, to solve for X, we're going to take 100,000 and divide it by 4%. Does anybody want to calculate your commission if you take 100,000 sales price and divide it by 4%? Are you seeing the number I'm seeing? Heck yeah. My commission would be $2,500,000. Booyah. Does it make sense to make a $2.5 million commission when you sell a $100,000 home? Guys, everybody would get their license, sell one transaction and retire, right? This would all we'd have to do. So, when we do math tutoring, hands down, the number one question I get is when do I divide, when do I multiply? Hands down. And one thing that the T-bar allows us to do is to do it both ways and see if one makes more sense than the other. I fear sometimes in the test, you guys see a math problem and you freeze and you stare at the question or you stare at a blank piece of paper expecting numbers to like magically form and do something. Guess what? They're not going to do it. Save yourself some precious test time and do it both ways. Multiply and divide and see which one makes more sense. It's Julie proof. Like I can't even mess this up, right? Always keeping in mind that that rate or percent goes in the bottom right. And now you have the other two figures to start with. We are going to do, well, we're not quite done with this, but we're going to take a break. But as I said, we're getting into our first testing math at the end of Unit 3. We're going to talk about taxes, property taxes. So we'll have our first real experience with the T-bar. Again, it'll be next week. So I got a few more things to say about this, but it is break time. So let's go ahead and take 10. When we come back, we'll finish this up and get going in Unit 3. And we're back. All right. So I am taking attendance. And let me get back in here and say just a few more things. But before we do that, let's take our newfound knowledge of the T-bar that we just discussed. And I have taken attendance. So if you're just now coming back, please let me know. Private chat. So let's take our newfound knowledge of the T-bar and let's apply this to the problem that we worked before we knew the T-bar. So here it is again. We know the answer. I'd like you guys to go back through it, only this time, use the T-bar to solve for it. So I'll give you just a few minutes. Get yourself set up in a T-bar and then we'll talk about it. So I guess the first question I have is, did you get the same answer this time as you did the first time we saw this? If so, you know you're doing something right. But again, we see a math problem. So what's the very first thing that we do? Just read it. Just read. Lane sells her home for $250,000, pays a real estate agent's firm a commission of 5% of the sales price. What is the total commission paid? The stem of my question wants to know the total commission. That's what this whole problem is about. Once we start getting into more complex, particularly in the math and some of these other areas, problems are going to start giving you guys distractors. Do y'all know what a distractor's job is? To distract you. So one way you can beat the distractor, that you can win over the distractor, is always keep your focus on what the question's asking. And if you see information in the problem that doesn't get you to the total commission paid, it's a distractor. So again, focusing on that question and only the stem of the question or the stem of the problem with the problem. In the problem. So we read the problem. I saw rate or percent without even thinking about it. No thought required. Throw down a T-bar, put in 5%. That's the no-brainer part of it. Rate or percent, throw down a T-bar, 5%. Now we need to figure out what to do with these other numbers. The other numbers we have are the sales price and eventually the commission. As we've already decided, which one's smaller? The smaller one is going to be the commission. That's the X that we're solving for. The whole is the sales price, which is $250,000. So on our calculators, we say 250,000 times 5%, and we're getting $12,000. Whoops. We're going to start with the T-bar, like I said, the end of unit 3. So I just wanted to introduce you guys to it, get you to start, thinking about it, encourage you guys. I'm very serious. If math isn't your thing, please look at that math facts section in the back of the book. It does a good job of warming us up. We start testable math next week, and we pretty much do math. Lots of units have math. We're going to do them as we come to them, but we're pretty much doing math in a lot of the units that we touch until we get to the end. So do what you need to this weekend to get yourself refreshed get yourself prepared, get your calculator, look at that math facts section, and get ready. Because it's coming whether you're ready or not. So wouldn't it be better to be ready? Another thing I want to talk to you guys about, remember earlier when we were looking at those test questions in Unit 1, and we talked about you could time yourself. You figure 2 minutes per question. So Unit 1 is a 20-question quiz. So if you want to take the Unit 1 quiz in your book, you just say 2 times 20 and you set your timer for 40 minutes. The other thing that you want to do when you're taking the quizzes in the book, you guys need to be grading yourselves because you need to be gauging how you're doing. If you take the Unit 1 quiz and you fail, what should that tell you? I got to go back and review Unit 1, right? We need to be grading ourselves. We need to be gauging ourselves as we go. You guys, if you're doing the quizzes the way I'm suggesting and you're grading yourself as you go, there should be no surprises on test day. Please don't fail Unit 1 and think, oh, I'll figure it out later. If you fail the Unit 1 quiz, you've got to go back until you get it. Unit 2, Unit 3, Unit 4. So how you grade yourself, guess what? We can use our new friend, the T-bar. So if you take the Unit 1 quiz, the percent of the rate in this case is your score. Once we take the quiz, we need to see your score. We need to see your percent. Remember, for my final exam, you have to make at least a 75% to pass. That's the minimum. I encourage you guys, I strongly recommend for the practice quizzes in your book, you strive to make an 80%, 85%, because if you can make an 85% on the quiz in the book, you're going to be better prepared for the end of class exam. Does this make sense? You know, 75 is the minimum. And if that's all you want to do, then shoot for a minimum of 75%. But if you want to position yourself, prepare yourself for the exam, I encourage you to try to do better on these quizzes. So we're looking for our score. The number that goes on top is the number you get right. The number in the bottom is the total number of questions. So even as you guys are doing these quizzes in the book, you can grade yourself as you go. So let's say, for example, you take the quiz in Unit 1. You know what you're solving for is your score. That's what we want to know. That's how we gauge ourselves. That's how we do, and that's our X. The end of Unit 1 quiz is 20 questions. And let's say you go through this and you get 15 out of 20 right. You missed 5. You only missed 5, but you got 15 right. The horizontal line means divide. So on your calculator, you take 15 divided by 20, and we get your score of 75%. My hypothetical question to you is, are you good with that? If you're good with the minimum, then great, move on to Unit 2. If you want to do better than the minimum, then go back through and study that unit again. Always study the questions that you miss. I don't care if you only miss one. Go back and study that one to help solidify that information. But again, you guys need, I really, really think you guys should be grading yourself as you go, so there are no surprises. You know what to focus your study time on. Remember Tuesday, I gave you, what did we say, 2 to 3 hours outside of class? So we're looking at like 16 to 24 hours a week. And a lot of times I get, Julie, I don't know what to do with that 15 to 20 or 16 to 24 hours a week. Take these quizzes, look up what you get wrong, focus on what you're not sure on, review it over and over and over and over and over again until you take the Unit 1 quiz and you get 20 out of 20 or 19 out of 20, whatever you're more comfortable with. So please start today working with a clock on the quiz books or the book quizzes and grading yourself as you go. Again, Unit 3, when we get there on Tuesday, we're going to get into some real testable math, but hopefully this gives you something to study with this weekend, something to practice with, and get yourself warmed up, especially if it's been a while since you've picked up a calculator. Do I have any questions or comments? I am going to stop sharing again just for 1 second. And while I'm doing this, you guys can go ahead and turn to Unit 3 in your book. We're going to jump right in there. We're on page, what is that, 51. Let me come back and get you guys. So Unit 3 is all about something called encumbrances. Now, of course, we're going to define an encumbrance, but I think it's important that we understand going into Unit 3 that the things that we talk about are encumbrances and things that can encumber real property. Again, we'll define that word in just a second. So in Unit 3, our roadmap, we're going to define what an encumbrance is, talk about what that means. We're going to talk about the different types of liens. A lien is an encumbrance, and we'll talk about what that means and the different types of liens. We're also going to talk about easements. Easements are also an encumbrance. Have you guys heard that word before, an easement? So we're going to talk about those and how they can encumber property. And then, as I said, we're going to get to property taxation laws. I doubt we'll get far into this today, so we know where we need to start on Tuesday, wherever we leave off. It very well may be starting Tuesday morning with math, just depending on how far we get. Yeah, and there's our math, calculating. So we're going to talk about property taxation laws, and then we need to calculate, do that math with property taxes. So first off, in Unit 3, let's define what encumbrance and encumbrance is. And an encumbrance is anything that affects title. I do not want you to get it in your mind that encumbrances are good or bad. Some are good, some are bad, some it makes no difference. An encumbrance is just anything that can affect the title. An encumbrance is a limitation. Even if you own a property, fee simple absolute, if there's an encumbrance on it, it limits what you can do or how you can use that property. Encumbrances are almost always appurtenant. Who remembers that big fancy word from last class? Appurtenant. I love you guys. I got one of you over here. What are you doing? You are running with the land, and appurtenance runs with the land. It runs with the land, and encumbrances are almost always appurtenant. An encumbrance is held by somebody other than the owner. If you have an encumbrance on the property, you don't have ownership. You don't have anything other than the right to your encumbrance. So it's not the owner of record, it's somebody else has permission So we're going to talk about the different, that's the rest of this unit is about, is the different types of encumbrances. And one thing, one encumbrance that affects almost every single parcel of real estate are liens. When you guys see the word lien, what I really want you to see is loan. Write that down. Lien equals loan. If you have a lien on your property, it's because you owe somebody money. Liens are a charge against the property. They offer security for the person that is owed the money. Liens are recorded. We're going to record them down at the public, at the courthouse in the public records. We will talk a little bit more about recording in this unit. We really get into talking about recording in Unit 5. So we'll get more in depth on that next week. But right now, let's just understand, if you have a lien on somebody's property, it's because they owe you money. And how you protect your interest, how you can ensure that you get paid, You go down to the courthouse and put a lien on the property. There is a lien order, a lien holder priority. So in other words, with lien holder priority, we're determining in what line all these lien holders are standing waiting to collect. There's an order that people get paid upon the sale of the property. What happens with the sale of the property? The seller sells. The seller sells at the sales price. Everybody that's owed money is deducted from the sales price. So all the lien holders are paid from the sales price. And once all that debt has cleared, once all that is finalized, the seller, in a sense, is the very last person in line. From the sales price, the seller gets whatever's left. Once they pay off the lien holders, there's an attorney's fee that we'll talk about, a couple taxes that we'll talk about. But once everything is paid, the seller gets what's left. It all comes from the sales price. Now, liens can be broken down into two different categories. We have two different types of liens. The first type of liens that we have are specific liens. Specific liens are specific to the property. Specific liens follow the property, not the person. Remember, we just said all lien holders are paid of the sales of the proceeds before the seller gets paid the proceeds of the sale. Everybody else is paid first. If any of these specific lien holders are not paid, it's going to attach to the property, which means the new owner could be stuck with the old owner's debt. Ain't that something? So how do we assure this doesn't happen? This is why we get attorneys involved in our closing process. This is why they do their job to make sure that what they're handing the new owner is free and clear of all previous liens. Again, we're going to talk about the attorney's process, what their end of the job looks like when we get to Unit 5. The examples of specific liens that we have. The deed of trust is your
I have a
mortgage.
question. I'm sorry.
Yes, please.
So specific liens always goes with the next buyer unless the attorney writes it differently?
She's got it because it attaches to the property, not the person. It doesn't follow the person. It attaches to the property.
Okay.
So the deed of trust is just your mortgage. As soon as you buy a home, assuming you go through a lender, assuming you need financing, the lender, once you record your new deed, the lender standing right there behind you to record their deed of trust. They want to be first or close to first in the line of people to get paid. So when you sell, they can make sure they'll get their money back. As I mentioned the other day, I have 2 units dedicated to the mortgage lender and that process. So when we get to unit 14 and 15, we get to wear a lender's hat and go through that process. But right now, let's just understand that a deed of trust is a mortgage. It's money that you buy, that you borrow to either purchase the home or you borrow against the home from a lender. Real property taxes are a specific lien. We're going to talk about taxes at the end of this unit, so we'll come back to that. Government special assessment. So let's talk first about what a special assessment is. A special assessment is a charge imposed on a property to improve. An example of a government special assessment. Maybe they issue a special assessment on your property because they want to install sidewalks, or they want to install streetlights, or maybe they want to hook an entire neighborhood up to public water and sewer. How they would charge the homeowner is by a special assessment. Failure to pay that special assessment will create a lien. Please hear the difference. You could also have a special assessment from your homeowners association, but HOA special assessments are not this special assessment from the government. Again, we're going to talk more about HOAs when we get to Unit 6. we're going to learn in just a bit that your annual real property taxes and your government special assessments are referred to as superior liens. Real property taxes and government special assessments are superior liens. What do you guys think that means? If I tell you taxes are superior lien, what do you think that means?
They take priority.
Yeah, they take priority. They're the most important. Kimberly said in the chat. Superior liens get paid first. Real property taxes and government special assessments. Guys, I always remember this way. The government makes the rules. The government makes sure they get paid first. Makes perfect sense to me. If Julie made the rules, do you know who would get paid first? Julie. So real property taxes, government special assessments. Again, we'll talk about lien priority in just a second. Another specific lien is called the mechanics lien. Please hang on to that for just 1 second. We're going to get into more depth in that on the next slide, so bear with me. And then the other special assessment is something called a North Carolina commercial real estate broker lien. This gives the commercial listing agent an opportunity to file a lien for any unpaid commission. Unfortunately, it's just commercial, not residential. There's a lot of legalities involved in that. So this commercial agent will need to call their attorney. Specific liens because they attach to the property. Specific liens because they're specifically to 123 Main Street. So before we talk more about this lien priority and our other type of lien, we got another type of lien to discuss. Let's go back and let's have a conversation about this mechanics lien. So first off, the mechanics lien fall under the North Carolina mechanics lien law. And the whole purpose of the mechanics lien is to give security to those that provide labor or materials to the improvement of real property. Why don't you guys tell us in a chat, what are some examples? Who are mechanics? Who are those that can provide labor or furnish materials? Who would be a mechanic? Contractors, builders, plumbers. There we go. Vendors. Let's get a little more specific here. Drywall people, electricians, subcontractors, surveyors. I know why you said that. Surveyors. What about painters, landscapers? We talked about contractors. Anybody that comes in, anybody that you hire to come in and improve your real property, if you don't pay them, they have the right to file a lien. I think that's so fair. Don't they deserve to be paid for the job that they did for you? And in order to protect themselves, if they're not paid, they have the right to file this mechanics lien. Any project, any commercial or residential project that is at $30,000 or more must have a designated lien agent to manage the project. This could be a general contractor, for example. And that lien agent, example of a general contractor, is the one that's charged with managing the whole project. And if we think about a project that is more than $30,000, we're looking at several subcontractors, aren't we? We're possibly looking at the guys that frame it, bring the wood in and paint and carpet and electrical and plumbing, right? There's several different subs, and all those people add up to more than $30,000. And the mechanics lien law says that they need to have a designated lien agent. Now, Do-it-yourselfers are exempt. It's only when you bring in that lien agent and the project's more than $30,000. The mechanics lien law says, in order for the mechanic to have a priority, to have a position in the payoff, and able to file the lien and get paid, the mechanic has 120 days from when they've last provided the labor and the materials. So they come to your home, they end the job today. They send you an invoice next week. They send you a second notice the following week, a third notice. It's clear to the mechanic that you're not going to pay them. They have up to 120 days from when the work ends to file the lien to ensure they can get paid when you sell. Failure to file the lien within 120 days means that the mechanic has lost their right to collect. They've lost the right to file that lien. Now they could keep harping at you, but they've lost the right to file the lien. Mechanics also have the opportunity to bring action to enforce. They could foreclose on your property if you don't pay them. Anybody you owe money to could take action to enforce. And if the mechanic wants to do that, they have to bring that action to enforce within 180 days. So the work ends today. We have 120 days to file the lien. We have 60 days after that to enforce. Everybody with me? 120 days from when the work ends, 180 days from when the work ends. Failure to meet this timeline, failure to meet this means that the mechanic has lost this right. So I briefly mentioned lien priority a few minutes ago. We're going to talk more about it in just a minute. We said real property taxes and special assessments are superior liens. We're always going to pay taxes and government special assessments first. The rules tell us lien priority after the government, after the superior liens. Lien priority says liens are paid back in the order in which they're recorded. It's a race to the courthouse. The first one that can get their lien down, their lien recorded at the courthouse, is going to have a higher position. They're paid in the order in which they're recorded. So superior liens and then liens after that are paid in the order in which they're recorded. Mechanics liens are an exception to this rule. So we have our superior liens. We have all other liens paid in the order in which they're recorded. The mechanics lien is not paid in the order in which it was recorded. The mechanics lien is retroactive, and its date, its paid date, is in the order in which the work began. What's the very first day this mechanic showed up on your property to start the job? That's their priority. So if another lien comes in after them and records, they have that priority of when the work began. Again, we'll talk more about lien priority in just one second. So mechanics lien is not paid. It's the exception. It's not paid in the order in which the work, in which it was recorded. It's paid in the order in which the work began. So we're going to look at an example together. I'll just put your pencils down for a second. Give your hand a break. Guys, please remember, if your hand's already a little sore, we are recording, and every single one of my PowerPoints are available to you in the online learning system. So please remember that's there if your hand's cramping a little bit. So let's look at an example, a couple examples together. Let's say on August 8th, your hot water heater goes out. You call the mechanic, he comes and replaces, or she comes and replaces your hot water heater, starts and finishes the job on August 8th. and then for whatever reason, you decide not to pay the water heater person. They have up until roughly 120 days from August 8th is going to be December 8th, 120 days, 4 months, give or take. If they want to file a lien against you to collect payment on the water heater, they have to file that lien by December 8th. If they want to take action to enforce, they have until February 8th. So we have 120 days from when the work ended. We have 180 days to take action. Now let's say August is a really bad month for you. Not only does your hot water heater go out on the 8th, 2 days later, your AC stops working. Are you kidding me? So now you call the AC guy. They come out, they do the work, they have to order parts, da 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 da. They complete the project on the 16th. The 120-day, 180-day clock starts when the work ends. So from 8/16, we count 120 days. If the mechanic wants to collect, if they want to have that right to stand in that priority, they have to file the lien by December 16th, and they have to take action to enforce by February 16th. This is the mechanic's time frame. Assuming you don't pay, just pay the bills. Wouldn't that be so much easier? But assuming you don't pay, this is the mechanic's time frames. So let's say you don't pay either one. You're like, great, I got new hot water and I got a new AC, but I'm not going to pay for it. So the mechanic, the AC guy, files the lien on November 20th. The hot water heater guy follows the lien on December 1st. Both are within their times. The hot water heater guy had till the 8th. The AC guy had until the 16th. So both filed their liens in line, which means they gave themselves that lien priority. They gave themselves the right to stand there when you sell their property, your property, and say, great, it's time for me to collect. Remembering that mechanics liens are the exception. All liens are paid in the order in which they're recorded, except for the mechanics lien that's paid in the order in which the work began. Why don't you guys tell me in a private chat of our AC guy or our water heater guy, who's going to get paid first? In a private chat, who is going to get paid between these two, just these two, between these two, who is going to get paid first? And again, I like to hear from everybody. So with mechanic lien priority, liens are paid in the order in which they're recorded, except for the mechanics lien that's paid in the order in which the work began. Who started first? The hot water heater guy. Who's going to get paid first? The hot water heater guy. It doesn't matter that the AC guy filed his lien first. Mechanics liens are that exception. Mechanics lien is the only lien not paid in the order in which it's recorded. It's retroactive. It goes back and it's paid in the order in which the work began. Again, we're going to talk more about liens, how attorneys can find these liens, what their role is, their responsibility, and making sure that the new owner gets their new property free and clear of any previous liens. Would you be mad if you bought a house today and they said, by the by, there's 5 liens on here that you got to pay to? You better believe it. So this is why we have attorneys, to make sure, again, that you can get that free and clear title. And we're going to get into that in Unit 5. So specific liens attached to the property. And unless they're paid off at closing, they become the responsibility of the next owner. They don't go with the person. They attach to the property. They're specific to 123 Main Street. The other type of lien we have is a general lien. These are the ones that attach to the person. General liens will follow you wherever you go. And anytime you try to go get a loan for a home or a car or what have you, this is going to pop up on your credit report. And you very well may not be able to get the loan until you pay off these general liens. So the general liens attach to the person. A judgment is a lien that's issued by the court of law. If you owe somebody money, the judge may put a judgment on you, allowing the creditor to collect. Personal property tax lien. Remember, we said real property taxes were specific. Personal property taxes are general. Personal property taxes are the taxes we pay on the cars, the boat, the RV. What are your toys? The jet ski down there. There's a motorcycle. Those are examples of things that we pay personal property taxes on. Failure to pay your personal property taxes creates a general lien that follows the person. State tax liens can be placed on the individual if they fail to pay their income taxes. If you inherit property, there's going to be a state inheritance tax. Failure to pay that would also fall under the state tax lien. And then federal tax liens is anything unpaid by the IRS. So any money you owe the IRS, they could file a federal tax lien. And again, you guys, these follow you wherever you go. If you own property, you're not going to be able to sell it until you pay these off. If you want to get a loan to get new property, you're probably not going to get a loan until you can pay this off. Somebody asks about like when you don't pay your car, payment of your car. I mean, so the person that you bought the car from, the only way they could file a lien on you, maybe they could go to the court and have the court put a judgment on it. Does that make sense? So if you owe money like to somebody, that's when the court could come in. And if the judge puts that judgment on you, then that would be insuring that person that you bought the car from.
So question.
Uh-huh.
Well, it's not really a question. So these people that put liens on, I guess, the houses and all that. So it could be where they will never get paid because what if the person never sells their house? They won't ever get.
If they never sell it, then they eventually pass and their heirs get to deal with it, right? But you could have cases, Jessica, where people owe more than what the home is worth. And those people are underwater. You have all these liens against your property, and there's no way you can sell your property for that amount. You may have heard that could be a foreclosure situation. That could also be a short sale. I don't know if you guys have heard about a short sale or not. We'll talk about foreclosures and short sales when we get to units 14 and 15. So if somebody's underwater, how they can get out of it. Guys, not all sellers get money from closing. To Jessica's point, sometimes sellers have to bring money to closing if they owe more than the property's worth. Thank you.
So how can they bring money to the closing if they don't have the money to pay the?
Then they got to face foreclosure or short sale. If they ain't got no money, they're in foreclosure or short sale. Because if they had the money, they paid off, right? Yeah.
Right.
Presumably. What's that old saying? You can't bleed a turnip, right? So if you don't have the money, you don't have the money. Real quick, we mentioned very briefly back in Unit 2, something about a homestead. We said homestead is for the legal life estates tend to be occupied by the family home. Please just make a note, unit 2. We also said homesteads are protected from most creditors. North Carolina has some homestead exemptions. We're not getting into details on these. It's just kind of an FYI. But there are some exemptions. Again, judgments, general liens. Again, all we're doing with this lien priority is making sure that the people that are owed money know what order in line they're standing in with their hand out, waiting to collect. And if the homestead is owed money, then they will, they'll be in that line as well. So let's sum this up. With lien priority, we said your superior liens were your real property taxes and your government special assessments. You guys should already have that written down. So your superior liens, these are always paid first. Recordation does not matter. The government's gonna get their money first. Real property taxes and government special assessments. After superior liens, all other liens are paid in the order in which they're recorded, except for the mechanic's lien that is paid in the order in which the work began. Questions on liens? As we mentioned earlier, we're going to talk about foreclosures when we get into our financing units. We'll revisit this because lien priority looks a little bit different in foreclosures. So that gives you something to look forward to. We'll talk about that. So liens are one encumbrance. The property is encumbered by the lien. Another encumbrance are restrictive covenants. Restrictive covenants are, let's call them the rules for the homeowners association, for the HOA that you live in. They provide restrictive covenants. They restrict, may have some restrictions on how you can use your property. Properties in these HOAs are encumbered by the covenants. We're going to talk more about covenants when we get to unit 6. But properties with covenants are encumbered. Another encumbrance is something called lis pendens. Here is your Latin lesson for the day. Lis pendens means litigation pending. There is an unresolved lawsuit on the property. The property is encumbered until we know the result of this lawsuit. At the end of the lawsuit, if the judge takes the property, the seller is no longer the owner. So what this encumbrance does, it requires the lis pendens to be recorded. And it's basically a legal stop. It says, don't you buy this property until we know the outcome of this lawsuit. Because if the judge takes the property, the seller can't sell it to you. So just think of a lis pendens as a legal stop. It's notifying us that there's a pending litigation. Another legal stop is something called a writ of attachment. This is when the court is kind of in the process of seizing the property. So if the judge is taking the property, they'll probably record a writ of attachment to let anybody that's thinking about buying it know, don't buy this property The court's in the process of taking it. If the court or the judge takes the property, y'all, the judge isn't going to show up on the front door and put the notice on the door and actually take the property. The judge is going to send the sheriff out to handle the seizing of the property. So again, because this is a process, as you can imagine, and while this is happening, we have this writ of attachment. Again, just a legal warning. Don't buy this property, because at the end, it's not going to be the seller's to sell. Another encumbrance, all about encumbrances. Another thing that can encumber property are easements. I don't know many properties that don't have an easement. I can almost promise you on your property, you have an easement. Let me ask you guys some questions and you can shake your head, yes or no. Do you like power? Do you like water? Those power lines, those plumbing, that water is accessible to your home from the city to your property through an easement. They have the right to run their lines, their pipes. That's one example of an easement. With an easement, you don't have any ownership. You don't own anything. With an easement, you have permission to be there. It's the legal right to use somebody else's land, somebody else's property. If there's an easement on the property, the owner of the property cannot stop the easement owner from accessing their equipment, their lines, their plumbing. You guys hear on the news every once in a while, somebody wants, I'm going to sue the city because the city showed up and, was doing something with their wires or their plumbing. Yeah, they have the right to be there. That's what that easement is. Good luck. So we have two different types of easements. We're going to break these down. The first type of easement that we have is called an appurtenant easement. What does the word appurtenant mean? It runs with the land. So this easement runs with the land. It's an appurtenant easement. And with an appurtenant easement, you're always looking at only two tracts of adjacent lands, two properties that butt up against each other. And it's always only two. You're not going to have more than two. And this easement is appurtenant on both tracts of land. So which means if either one of these guys sells, the easement runs with the land. The easement goes with it. It passes with the title. Oh, I'm giving examples, never fear. So the two tracts of lands, the two adjacent tracts of lands, they have names. One of those tracts of lands is the servient tenement. The other tract of land is known as the dominant tenement. One is being used. The other one is doing the using. The servient tenement is being used. They're the ones that the easement runs over. The dominant tenement is the one that's benefits. They're the ones that are doing the using. Let's look in your books on page 56. So we got a picture on page 60 or 56. What did I say? 56. Here. Just in case I didn't say that right. 56. So you got lot A is the servient tenement. You got lot B is the dominant tenement. I'm asked to repeat that. The servient is the one being used. The dominant is the one doing the using. So you guys see, for whatever reason, lot B cannot access the public road. Now, I don't know why they can't tear those trees down and build a driveway. Maybe those trees are protected. Maybe the city has that protected and you can't touch the trees. That's going to come back up in zoning when we talk about that in Unit 6. But for whatever reason, in order for B to access their property, they have to drive over A's land. You guys see that? B is the dominant because they're the ones that are using Lot A. Lot A is a servient because they are the ones that the easement runs over. I think a lot of times, and y'all excuse me, I'm not an artist, but I think a lot of times where we see the creation of an appurtenant easement, let's say you have a tract of land and here's the road. I actually showed this property a couple years ago. So you have a piece of land and here's the road. And at some point, this owner decides to divide the land. And now I have two tracts of land. This is owner A, this is owner B. I have shown this property. And when I showed B, the buyers to B, we had to explain to them that they had an easement of the driveway so they could drive over A's property to get to theirs. A owns the driveway. A is responsible for maintenance. They pay taxes on it. The driveway is A's property. They are the owner. Now, can they go knock on B's door and say, hey, man, you want to chip in to repair our driveway? Sure, they can. Does B have to chip in? No, they don't own anything. They simply have an easement. Joe, we're going to talk about landlocked. Yep, in just a second. And to your point, you can't landlock somebody. You can't deny somebody entry or access to their property. So this has to happen in this case. A pertinent easement, always and only two tracts of land. You guys have that written down? A pertinent easement is only two tracts of land. The servient and the dominant. The dominant is the one that benefits from the easement. As we mentioned, well, no, I don't think we did. Easements need to be recorded. It just makes it enforceable against whoever purchases. Again, the attorney is going to do a very thorough search of these public records. Before you buy a property, the attorney is going to say, oh, wow, you have an appurtenant easement. Your buyer is going to look at you and say, what does that mean? And you're going to say, call the attorney back and ask him. So easements are recorded. This is how we can find them. This is how we know they exist. Another example of an appurtenant easement could be a party wall. We talked about these earlier with our townhomes, that common wall. Could also be a shared driveway. If you look here, both owners, greenhouse and yellow house, have the right to use this driveway. They probably own the property straight down the center of the driveway. But because of the appurtenant easement, they're both allowed to access the driveway so they can get to. And look, you guys see this? Their garages even have a party wall here. So when the tree falls and lands on both garages, both parties are affected by that. Both parties will have to be involved. Call your insurance agents. Questions on appurtenant easements? Possibly a shared fence. Yep, if they're hitting both tracts of land, could be. Okay. So let's go ahead and take our last break, I guess. Not our second break, but our last break. When we come back, we're going to talk about the second type of easement. All right, we are back. So our cameras are back on. Make sure you can see the light. So I'm going to take attendance. Nope, Denise, I just got you. You're in. So two types of easements. We talked about an appurtenant easement that affects how many tracts of land? You can show me, I can see. How many tracts of land? Two, and only two, the dominant and the servient. The other type of easement we have is called an easement in gross. Did we skip a slide? No, we're good. An easement in gross is an easement. It could be on one tract of land. It could be on thousands of tracts of lands. An easement in gross is the right to access the property. Guys, this is where our utility companies have easements, maybe R&R Railroad, for example. Good, Martha, that's a good idea. So an easement in gross. There are two different types of easements in gross. There could be a personal easement in gross. There could be a commercial easement in gross. A personal easement in gross, well, actually, neither one of these run with the land. Neither one of these are pertinent. So a personal easement in gross is only as good as you own the property. Once you sell the property, then the personal easement in gross disappears. An example of a personal easement in gross, if I had some really nice property, and let's say I had a very nice pond, and you wanted permission to come fish on my pond, come on my property and fish on my pond, I could grant you a personal easement in gross. I could give you permission to come on my property, fish on my pond. When I sell my property, that personal easement in gross goes away, which means you can't come back and fish. And if you do, I think some people call that trespassing, unless you create a relationship with the next owner. You guys with me? So this personal easement in gross, this permission to come fish on my pond, is only as good as long as I own the property. The commercial easement in gross is Duke Power, R&R Railroad, whomever you have that's coming on to service their equipment or service their power lines or whatever, their railroad. Some properties, for example, that have railroad tracks running down the back of them, they're knowing they're buying with that commercial easement in gross. These are also not appurtenant, which means if Duke sells, let's say Duke Power sells to somebody else, that commercial and easement in gross doesn't automatically transfer to the next owner. Now, Duke Power has good attorneys, and they will write that up as part of the offer, part of the contract, that is going to happen, that the new owner will have their own commercial easement in gross. But understand, it's not automatic. It has to be created. With either easement and gross, there's no dominant. There's only a servient estate that's being used. And again, once the easement owner sells, or in the case of Duke, if Duke sells or closes their doors, then the easement, the commercial easement and gross, will terminate with them. Again, another picture in your book, page 57. We still have lot A and lot B, but now we also have an easement and gross with power lines. Obviously, it affects A more than it does B, but they both still have that easement and gross. And if Duke needs to come on the property to service these power lines, there's nothing you can do about it. They have permission to be there. That's what an easement is. You can't go out and tell the train not to drive on the tracks that are on your property. They have permission to drive on those tracks that run through your property through R&R railroads, commercial easement and gross. I'm going to go off book just for 1 second, because we're getting ready to kind of introduce you guys to some new words. So before we get back into the book, I want to make sure we understand these words. Now we're going to see these again. We're going to see them in Unit 7. We're going to see them in Unit 9. But I think it's important that we understand something that is an express agreement versus something that's an implied agreement. If it's an express agreement, it's expressed because the terms are clearly stated. The terms of the agreement have clearly stated. Maybe they have been stated orally. Maybe it's in writing. It's not expressed because it's oral in writing. It's expressed because the terms have been stated. Now we're going to talk about verbal agreements when we get into contracts. I'm here to tell you guys right now, if you got verbal, you got nothing. So obviously we want to make sure everything's in writing. But for the basic definition of express, the whole point is that we clearly state the terms. Compare that to an implied agreement. The terms aren't stated. Instead, they're based on actions. They're based on the parties' actions. The agreement is implied because of how we are conducting. We'll see these, we'll define them in 7, we'll define them in 9, we'll talk about them the rest of this class. This is just basic kind of 101 to ease us in. So back to the book on page 57, there's 3 different ways that easements can be created. An express easement, an express agreement means that the easement was created because the terms have been clearly stated. Think an example of an express agreement is the party wall of a townhome. When you buy a townhome, you know you share a wall with the person that lives next to you and both sides of you if you're in the middle. An implied easement is one that was created by the actions. We haven't expressed the terms. We haven't discussed what the terms are, but just based on our actions, the implied easement was created. It's a result of the surrounding circumstances. An example of an implied easement is an easement by necessity. Somebody asked a few minutes ago about landlocked. You can't landlock somebody. You cannot prevent them from accessing or leaving, coming or going from their property. So if somebody's landlocked, it's implied that they need this easement by necessity. It's necessary for them to come and go. Easements can also be created by operation of law. So if the judge comes in and creates an easement, an example of an easement created by the judge is an easement by prescription. And what an easement by prescription says, somebody is going to the judge and claiming permission to be there. They're going to the judge and saying, look, I've been using this person's land for like 20 years, for example. And because I've been using this person's land for 20 years, I want the judge, I want the law to officially give me permission. Maybe the judge will grant the easement by prescription, maybe they won't. If they grant that easement by prescription, then the easement has been created and that claimant has the right to use the land. It's a long period of time. Like I said, about 20 years. Remember, you guys, easements are about permission to be there. When we get into unit 5, we're going to take an easement by prescription a step further. Easement by prescription says they're going to the judge and asking permission to be there. When we get to unit 5, we're going to learn that the claimant may be able to go to the judge and say, I just want the property. Just give it to me, deed it over to me. You could lose your property. Again, we'll talk about that. It's in unit 5. You can't wait till next week. You're looking ahead. It's called adverse possession. You're looking ahead. And then to wrap this up, on page 58, we talk about how easements can end. The cessation of purpose. If the purpose why the easement was created no longer exists, then we have no reason for an easement. Let's say, for example, you own a large parcel of land and the back part of your land, for example, is timber. And you grant an easement to a timber company to come harvest the timber from your land. Once they harvest all that timber, they got what they needed. There's no reason for them to be there. That easement's purpose would be no more. Cessation of purpose. Merger of the parcels. You guys remember our earlier example where we had 2 tracts of land? Owner A and owner B. If B buys A or A buys B, we've merged the 2. There's no need to have an easement now because now we're just down to 1 owner. So we've merged the parcels. If the easement is released by the court of law, if the judge terminates the easement, and then if the easement or the piece of land, the tract of land is abandoned, that could also terminate the easement. The one that didn't abandon could possibly go to the judge and request the termination of the easement because the user isn't using it anymore. Remember we said when we started this unit that just about everything in here is an encumbrance. The one thing in here that's not an encumbrance is a license. A license is not an encumbrance. Everything else in this unit is an encumbrance. We can compare a license to a personal easement in gross. Personal easement in gross. So once again, you're getting permission to come fish on my land and fish on my pond. The difference is that the license can be terminated throughout my ownership. Personal easement in gross, you get to come fish on my pond as long as I own the property. A license can be terminated. So if you start abusing my pond and leaving all your beer cans and everything by my pond, I could go terminate the license and now you don't have permission to be there. That's the only difference in the license and a personal easement in gross. So the license can be terminated in my ownership. And it's not an encumbrance. Personal easement in gross is an encumbrance. So back to our conversation about encumbrances. Another encumbrance is an encroachment. Encroachments are bad. Encroachments are really, really bad. As a matter of fact, they are so bad. When you see encroachment, y'all see the word roach? Like right smack dab in the middle there. Ugh, that's how bad they are. They got the word roach in it. Bad, bad, bad. With an encroachment, An improvement on your property is extending over the property line onto somebody else's property. Your improvement is expanding past your line onto somebody else's property. Why don't you guys tell us in a chat, what do you think are some good examples of an encroachment? What's an improvement? And I'll tell you the number one once I hear from you guys. But what do you think is a good example of something that could be an encroachment? See, I see the fence, fence line, fence, 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 fence. Guess what the number one is? The fence. If you have a building, if you have a shed, absolutely. It could be an encroachment. But I think, in my experience, the number one encroachment is a fence. Guys, we're going to talk about property lines and surveys when we get to Unit 4. The only way to discover an encroachment is through a survey. It blows my mind how many people install a fence in their yard and don't have it surveyed. They assume they know where their property lines are. Blows my mind. I think, nobody has ever called and asked me, but I think if I were a fencing company, I'm not going to install a fence until you get a survey. So we know where we're putting it. Now, obviously that rule's not followed. The fence is probably, and of course you can have others. You guys gave some great examples. But I think the fence is the biggest encroachment. And it's probably one of these things that is not a problem until it's a problem. And now it's a problem. What do I mean by that? You build a fence, it comes over on my line, just even a little bit, just a teeny tiny. My property line is my property line. And I say, whatever, I'm not in the mood to argue with you. It's not a problem between us. It becomes a problem when one of us goes to sell. Because the buyer hopefully will have a survey done, discover this encroachment, and it's got to be taken care of before we can convey, because encroachments make both pieces of property unmarketable. How do we fix an encroachment? We have two choices. You either tear down your fence or move it and get it off my property line, or we create an easement. I give you permission to be there. Guys, the only thing you know by looking at a fence is that somebody put a fence there. It in no way tells you the property lines. You cannot eyeball it and say, oh yeah, that's on my line, that's on yours. The only thing you know when you first look at a fence is that somebody put a fence there. Y'all want to hear a funny story? It's like not funny, haha, but it's funny like this is people, My husband's boss last year, his neighbor put a fence up. Boss's neighbor put a fence up and then had the survey done. Kind of did it backwards there, didn't we? Guess what the survey revealed? That brand new fence is on the boss's property. Y'all want to know what neighbor did? Knocked on the boss's door and said, you need to pay to take that down. Boss said, no. I don't know where it's at now. I know they're still, last I heard, they were still battling it. Isn't that something? Again, we'll talk about property lines, identifying property lines and surveys when we get into Unit 4. Here's a nice picture. So you can see the red is the property line. And this is some kind, I'm not sure what kind of building this is, but look at how much of that building is going over on, that's a huge encroachment. The neighbor's garage, oh, it's a garage, okay. The neighbor's garage. So again, we have two choices. I either make you take that piece of your garage down, get it off my property, or I grant you an easement. I give you permission to be there.
Question.
Yes.
Would you say it would be more simpler to just create the easement versus, I know you just don't want to go to court and have to do all that, but would it be easier to just do the
It
easement?
would be easier, Rhonda. Bottom line is going to come down to what the parties agree to do, right? So it's going to come down to agreement of the parties.
Right.
Would it be easier? I mean, me as the owner of this garage, heck yeah, it'd be easier because then I don't have to tear my garage down, you
Right.
know? You as the owner of this person in the red, you know, it might be easier for you to tell me to get my garage off. And guys, I mean, put real estate aside for a second. If two parties can't agree to agree, the judge will decide for them.
Right.
So
It could get
if you and
nasty in
I
court.
can't come to terms, then now we're winding up in court anyway. Rhonda says,
Yeah.
why don't you just grant me the easement, right?
Yeah. Let's not get nasty.
But yeah, bottom line, I mean, again, putting real estate aside, if two parties can't agree to agree, that's when we go see the judge and let them decide. Let's see, they can't build that after you buy the house without your permission. Well, I mean, they can, they shouldn't. That's what the encroachment is. I didn't give them permission to put this here, but they went and did it anyway. And that's why we have this encroachment. Could you sell this piece of the land? Absolutely. That's another great option. So we could just kind of redraw our line here, right? And resell this property. Now I want money, of course. But again, we're getting the judges and attorneys involved. Could the property owner take possession? Absolutely. We could do an easement. What can we do? I love that. Thank you. What's this mean to us? This is another place. If you're getting ready to sell, if you're getting ready to list either one of these pieces of land, or you're working with the buyer, maybe the buyer has the survey done and discovers this, that's when we advise them to talk to their attorney to figure out how to get this handled, how to get this cleared up. So what can we do? You know, we're going to have them talk to their attorney so we can sell the property. Okay. All right. Another encumbrance, and actually back to our liens, particularly our specific liens. Let's talk about property taxation in North Carolina. First off, why do we have property taxes? Well, property taxes help support government functions, various city property taxes, county property taxes. You may have school board taxes. You may have fire district, EMT district taxes. Understand early that all cities, all counties have the right to do their own taxation. There is no flat across the board from the state that says this is how you're going to do your taxes. Cities, counties, municipalities, for the most part, they have their own flexibility there. And in North Carolina, we use an ad valorem property taxes. Ad valorem just means at market value. So whatever the tax appraiser determines is the market value, that is our ad valorem taxes. That is our assessed tax amount. Ad valorem taxes express the tax rate as the tax rate per 100. Do you guys remember earlier when we were looking at our math and we said the word of means multiply? A lot of times, not every single time, but a lot of times when we're looking at this and we see the word per, and in this case, the word per means divide. So when they're giving you the tax rate, an example, they may say the tax rate is 1.2 per 100. So what they're saying the tax rate is 1.2 divided by 100, which gives us a tax rate of 0.012. There it is. This is kind of our introduction for the math that we're going to get into, looks like very first thing Tuesday morning. If we don't start it today. There's a couple different things that go on when we look at property taxes. You have the tax rate. Tax rates can change from year to year. Cities, counties, municipalities can set a new tax rate each year. And it's based on how much do they need to operate this year. The other piece that we're looking at is the assessed value. How much does the tax department think that the property is worth? Please understand, when we talk about value, I got two different types of value. I have value that the appraiser puts on it for the purposes of purchasing and originating a loan that we will talk about in Unit 17. And then we also have the process of the tax assessor putting an assessed value on it. And that's to determine how much tax we can charge this year. Please understand, all property in North Carolina is subject to property taxation. You may get maybe some not-for-profit organizations that own property. They may get some tax exemptions, for example. So they may not have to pay as much because they're not for profit, but they do have some sort of property tax. Everybody across the state. So we said earlier that ad valorem taxes are per city, per county. The state doesn't regulate how everybody's going to charge their taxes. However, the state does give us a Machinery Act. Let's think of the Machinery Act as the ceiling. The state puts a limit on how much cities and counties and municipalities can charge. So they can't go nuts. The state comes in and puts a ceiling on it. They put regulations in it. They regulate how property is taxed, how it's assessed, how it's appraised for assessed value, and those tax exempt statuses, for example, the not-for-profit organization. So while there is flexibility within each city and county, they also have some limitations, again, just to keep them from going nuts and charging us way more. So the Machinery Act, and I think the problem topic on this is the name, the Machinery Act. Because 2 months from now, when I say Machinery Act, you're going to go, what's that? So that's the problem topic, is just remembering that the Machinery Act has to do with regulating taxes. We mentioned earlier the different ways we can assess. Like I said, in North Carolina, ad valorem taxes. We pay our taxes 100% of the tax market value. Other states, that tax assessed value may be less than market value. This is important. Please listen to me. When we get into the math next week, we're going to see math problems where they tell you to use the assessed value, or where they tell you to use less than the assessed value, but never both in the same problem. So when it comes to these, you always do what the problem tells you. Y'all don't argue with the problem. You guys like to do that. You will argue with a problem all day long. But if you see a problem that talks about the assessed value is less than market value, just know in your mind you're standing in another state. But we're always going to do what the problem tells you. So either they tell you to use 100% or they tell you to use an amount less than that. And we'll see that next week when we get into the math. I love starting the week with math. Coffee Tuesday morning, okay? Okay. So we said North Carolina does ad valorem, which is the tax rate per 100. So North Carolina does ad valorem, tax rate per 100. Other states, and I don't know what other states, but other states may use what's called a mill rate. And a mill is 1/1000th. So if the problem tells you that taxes are, the tax rate, the mill is 15 mills, you just take 15 divided by 1,000. And now you have your tax rate or your mill rate of 0.015. Ad valorem is per 100. Mill is per 1,000. Again, the problem will give you one or the other, never both. So we're going to do what the problem tells us. If it tells you to use a mill, use a mill. If it tells you to use ad valorem, so mills per 1,000. So just to sum this up, North Carolina is ad valorem. Our taxes are based on the assessed value, 100% of the assessed value. Other states are going to use a mill, 1,000th. The assessed value is going to be less than. Again, the problem will give you one or the other, not both. By the way, all the math, you guys, is in your national section. There is no math in your state section. So that's why in the national section, you may see ad valorem, you may see mill. There's no state specific math. So let's talk about North Carolina's taxation timetable. Now you don't need to write this down. Everybody turn with me in your book on page 64. What you're looking at here is already in your book. And I'd like you guys to make some notes in your book so that this makes a little bit sense. The timeline that we're looking at, this is the current year, 2023. Except for this one date, January 5th. That January 5th date is 2024. I'm going to talk about the whole thing, but I'd like you guys to make that note in your book so we know that we're talking about this year, except for the January 5th. January 1st, every single year, a tax lien is filed on all properties in the entire state of North Carolina. Happy New Year, January 1st. They start looking at the taxable property listed in the month of January. Where are my homeowners on the call? Where are you guys at? Did you guys get your tax listing letter from the city county yet? Mine came from the county like yesterday. And you'll get it. Check your mail today. It'll probably be there. And basically what the county want to know is, what is my taxable property? Is there anything I have, like, for example, do I have an RV this year that I don't have last year that would have personal property taxes? So if you haven't gotten your taxable property letter from the county yet, all counties are different, but I bet you it'll come sometime in the month of January. What they're doing is compiling the information. Fast forward to July 1st. July 1st is when they set the tax rate for this year. Again, that tax rate can change from year to year to year. So when you have this tax lien filed on you on January 1st, you have no idea how much you owe yet. All you know is that you owe taxes this year. July 1st, they assess the tax rate, set the new tax rate to make sure that they can continue supporting their government functions. Bills are mailed in August. Taxes each year in North Carolina are due and payable on September 1st. We have the lien filed on us on January 1st. We can't pay the bill until September 1st. They're still compiling the information. Failure to pay taxes this year means on January 5th, the deadline, January 5th, 2024. If you don't pay them by January 5th, 2024, then they can start charging interest for delinquent taxes. They're obviously not going to remove the lien. So on January 6th, you'll have a lien from last year's taxes. Again, my homeowner's on the call. If you purchased using a lender, you don't have to worry about paying taxes, do you? Because your lender handles that for you. They take money each month and put it in an account just for you. And at the end of the year, when the bill comes due, they pay those taxes on your behalf. If you don't have a loan, then you're responsible for paying the county directly yourself. If you pay it off or if you were a cash buyer. Again, that's part of the mortgage lending process that we will talk about units 14 and 15. So if you don't pay it by the 5th, interest starts accruing on the 6th. You have a real property tax lien that's a superior lien, and you can't convey your property until that is paid off. What if you're selling your house? What's today? Today's like January 5th, I guess. Okay. What if you're selling your house today? Anytime a seller sells their home, the seller and the buyer are going to share this year's taxes. So we're going to share that expense. We're going to take that expense and we're going to prorate it between the two of us. We're going to talk about prorating and how this works and actually get to look at the math on how to do this when we get to unit 21.
Is this where, like, for example, if the seller sells their home to the buyer and the seller lived for that year in the house for 6 months and it passes to the buyer at the 7th month, and then like at the end of the year, you pay for your portion, they pay for their portion?
Not at the end of the year, but at closing. We're going to hash all this out at closing. So you're absolutely right, Brenda. The seller's responsible for their 7 months. The buyer's responsible for their 5 months. Isn't that fair? If you buy my house in June, is it fair for me to pay the whole year's taxes? No. If you buy my house in June, is it fair for you to pay the whole year's taxes? So what we're going to do is we're going to prorate it and make it fair at settlement. So we have that math, and thank you for that question. So we have that math to look forward to when we get to unit 21. So you buy my house in June. June's what, right about here? We don't even know how much taxes are this year, do we? We don't know 2023 taxes until we get the bill in August. So if you buy my house in June, the best thing that we have to go by is last year's taxes. So until that bill comes out, until we see the amount due this year, the best thing, and really the only thing we have to go by, are there some fluctuations from year to year in taxes? Yes. The thinking is they're not going to go up that much. I guess I could say they're not going to go down that much, but taxes don't go down much, do they? Let's face it. So for the most part, taxes aren't going to go up that much. The only other way you can avoid this is only do real estate after the bill comes out in August. And guys, people buy houses in March, they buy houses in May, they buy houses before the bill comes out. And all we have to do is rely on last year's taxes. So we said earlier that the tax rate can change each year. The tax rate, everybody see this? The tax rate can change each year. The other piece of this is the assessed value. What does the tax appraiser determine as the assessed value of the property? In North Carolina, we use an octennial reappraisal, which means cities, counties, municipalities need to reassess their assessed value every 8 years. So the tax rate can change from year to year. The assessed value is going to change every 8 years. Octennial reappraisal. They're reassessing that assessed value. Cities and counties also have the opportunity to do what's called a horizontal adjustment of the assessed value. They can do this every 4 years. A horizontal adjustment is across the board. Everybody in this county is going to have a 0.5% increase of assessed value. It's across the board for all. So we're reassessing every 8 years with the option to do a horizontal adjustment. What applies to one applies to all. We mentioned earlier the process for the appraisal to purchase and to originate a loan is different than the assessment for tax purposes. Appraisers generally do both. They'll do the appraisal for purchasing. They'll also do the tax assessment, but the process is different. When we talk about the appraiser for the purposes of originating the loan, we're going to learn that the appraiser studies that specific property. They're going to go out and study and put value on 123 Main Street. When they're doing tax assessments, they're looking at a whole area. They're not just looking at one property. So maybe it's a subdivision or a neighborhood, you know, depending on size, population. They might draw the city map and quarter it and use that, as opposed to studying one specific property. Guys, it amazes me over my years, depending on the market, how people like to look at the tax value and think that that means that's what the property's worth. What the property's worth and the tax value are two totally different things. And that's a big part of our job, you guys, is helping to educate the buyers and the sellers. So this crazy seller's market that we're coming out of, actual value, purchase value has been way higher than tax value. Because of the market that we just came out of, I promise you, the next time they assess us for tax purposes, it's going to be a lot. Property gained a lot of value in the last couple of years, and the government absolutely will capitalize on that. But my point is because you're buying, because this is what happens, right? You're working with a buyer and we see the sales price is $250,000. This is the market we've been in. And then we look at the tax value. And the tax value is, I don't know, $169,000. And the buyer says, that's not fair. Why do I have to pay $250 when the tax value is $169,000? This is our job to explain the difference. This is our job to let the buyer know that the tax value and the purchase price or the appraised value are not the same thing. We cannot look at that. The only thing we do when we look at the tax value is let the buyer know this is what it's assessed at right now, subject to change. Also with the government, we talked earlier about our special assessments, our government special assessments. Government special assessments, again, are levied by our local government, maybe the county, city, township, municipality, however it's created and operating. And the whole purpose for a government special assessment is public improvements made to the property. Maybe you're going to install sidewalks, street lighting. Maybe you're going to hook a whole community up to public sewer or water. Remember, our government special assessments are superior liens. So delinquent real property taxes, now that we know what that means, delinquent property taxes are always paid first after January 6th. Then our government special assessments. And after that, lien priority says liens in the order in which they're recorded, except for the mechanics lien that's paid in the order in which the work began. We will talk about homeowners association special assessments when we get to unit 6. 2 different special assessments. Only the government special assessment is a superior. Questions? Okay. Well, we're going to end here today. Don't go anywhere just yet. Don't go anywhere just yet. I fear I say that and you guys go launch for that leave button. Hang on just a second. So when we come back together on Tuesday, we're going to pick up with the math. I'd like to point out, please look with me on your book on page 63. Units in your book that have math have something called these math concepts. So here on page 63, 64 is your introduction to the math that we're going to start with on Tuesday morning. I encourage you guys to look at this, get ahead of the game and start looking at this. We're going to talk about annual taxes, assessed value, tax rate, and how we determine how much those annual taxes are. We get to use our T-bar, so that'll always be fun. Do you guys see on page 63 near the bottom, it says example 1, example 2, example 3. Do you guys see that? As you're looking ahead and you see these math concepts, y'all, we don't read math, we do math. So as you're looking at these examples in the math concepts, pick up your pencil and your calculator and work through. It means nothing to you to say 1.67 divided by 100 equals 0.016 times 120,000. That means absolutely nothing. So actually do the math. Take a piece of paper and cover the solution there if you need to. See how you do. But don't read math. Do math. You guys are going to get it better when it's going to click more when you see it in your own style of doing it. So again, I encourage you to look ahead. Page 63 is where we're going to start on Tuesday. Once we are done with unit 3, we go on to unit 4. We'll do unit 5 next week. We'll probably get through unit 6. So please look ahead. I know a lot of you have already looked at the first 3 units, and guess what? We're just about done with those first 3 units. So remember, your homework after every class is to review what we covered and look ahead at where we're going. Also, don't forget this weekend to go calculator shopping if you haven't already. Also, please remember, thank you, by the way, for those of you that have sent me your selfies and your introductions. I do love meeting you guys. So if I haven't received your selfie and introduction yet, please send it to me this weekend. If you send it to me, I've responded. So if you think I sent and I didn't respond, that means I didn't get it. So try resending it to me. I'll check my spam this afternoon as well, because sometimes you guys land in spam. So I'll do that as well too. Otherwise, it's 12:59 and I kept you guys a minute on Tuesday. So I'm going to let you go a minute early today. Are we even now? Are we fair? All right. Y'all have a great weekend. Find that balance between work, life, family, play, fun, study, right? And I will see you guys first thing, Tuesday morning, 9 a.m. Thank you.